But extremely important to remind you, Lordship, the last week, I just do a Lordship conditions that are earlier. I mentioned matter was kind enough. Yes, matter appears in the supplementary list. It appears, but by mistake or some, I cannot blame anybody. Maybe it's a technical defect. Again, it has disappeared. So my lord can't me to leave. Better you come on Monday. Perhaps have the notice. Let it appear in the supplementary list, my lord. To number to chaichile.
With regard to motions, my lord, is appearing in the combined list is long, my lord. If your lordship kindly permit, my lord.
Oh, Jhadik na.
With regard to mutation only, my lord. Very short.
Mutation of which property?
May I leave, my lord?
Group 1, my lord. Group 1.
Mutation of which property?
These whole property at Kolani.
At Kollani?
Yes.
Give the number.
Correction of typographical error in the order sheet dated 24th August 2023.
Correction.
May your lordship's kind indulgence to with notice to other side, my lord, extension of interim order. Interim order is expiring on 31st of August. I have served notice. Server copy is also annexed.
My lord, may I
Extension of interim order, my lord. Extension of
Yes.
extension of
Give the number.
yes.
My lord, one motion, my lord.
My lord, may I-
Appearing, my lord, the AO has been filed, but the petition is not filed.
You are appearing for the respondents.
Upon notice.
The number, let me see.
My lord, may I be permitted to mention, my lord, the matter was mentioned before your lordship on 22nd of August. After satisfying, your lordship was fixed, allowed to make it appear on the list, but this matter is very urgent because, my lord, matter relates to extension of list, my lord. Any point of time, my lord, tender may be issued over my plot of land. Whereas your lordship's order of stay is,
Supplementary list.
yes, my lord, 161, my lord. Kindly, my lord, it's a very urgent matter, 161, my lord. On it mentioned earlier, my lord. And to that effect, another notice was given also.
This is under the heading mentioned matters in the list. Give the number, let me see.
Another extension of inter.
But extension of interim order.
Mentioned matter.
Extension
I'll have content application.
Give the number.
Extension of interim order, my lord.
Whenever the extension of inter.
Content application.
To the unauthorized occupancy of government land. my lord.
Content.
I have no interest in this. My lord, it's appearing in the monthly.
How many matters are you holding?
My lord, two only. I have given one.
Give the
my
numbers. Give the
respondents,
numbers.
only 2
But
matters.
extension of interim order.
Extension of interim order.
My lord, I am mentioning.
Matter is, my lord, is in the monthly list, my lord. I'm saying, my lord, kindly inclusion in the daily list.
What is your urgency?
My lord, on matter, my lord, I am for the private respondents, my lord. By filing the writ petition, the petitioners are harassing the private respondents, my lord. If showing the
Have you put
pendency of this
the,
writ
have you
petition,
put
my
the others on notice? The petitioners?
my lord, matter is already in the monthly list, my lord. I will serve notice in
Wait,
the course
no.
of the day, my lord.
Mention upon notice, because you're the private respondent, you're not the petitioner.
My lord, another matter, I am for the petitioner, my lord. This is second round of writ petition, my lord. In 2015, my lord, there was an direction for payment of compensation, my lord, has not been paid yet, my lord. I am for therefore, my lord, second writ petition is filed, which is pending before his lordship, my lord.
It's in the monthly list.
Yes, my lord. Item number 718,
Give
718.
the number, give the number. The other one, please, put the other side of
My
notice
lord,
and come
I
back.
am mentioning one urgent matter. This is item number 94 of today's list. My lord,
Mention
my lord,
today's list. I
my
will
lord-
not upgrade today's list.
my lord, this is my lord, after my lord, your lordship's order compliance. My lord, they have demarcated, they have surveyed, and they have found that entire plots, my Vastu plots, have been blocked by the private respondents by encroaching the government land, enter egress and ingress portions. My lord, they heard it. They just verbally requested the opposite party, my lord, the private respondent to remove the structure. My lord, 6 months ago, my lord, they directed them. As yet, my lord, it has not been removed. I am not in a position to either enter or, my lord, go outside.
Turn, I'll take up the matter.
Previous occasion, I mentioned this matter, the petition is a cancel, which now is counted in state. This matter is an upgraded item number 62. Yes, but can annex the medical report.
62 of the supplementary list. Please wait for your turn. Let me see, I'll take up. I have from today actually separated the mentioned matters from the regular matters. So let me see if I can take up.
Madam, may I permit you to mention, my lord, the application is connected to the amendment of the writ petition, my lord. Your lordship was directed to fix the matter for hearing, writ petition for hearing on 30th August. Before that, if the application
You're asking for an amendment.
amendment of the writ
The
petition, madam,
application
kindly
document.
fix the matter any day before 30th August.
Let me see. Yes,
Item 76, 77, and 78 of the monthly combined list of this month, which was appearing in the monthly list of July, item number 42, 43, 44. And 32 matters were taken up by my lord in July.
yes.
Now I have got demotion instead of promotion. So my lord, I pray, let these 3 matters be updated.
It's in the monthly list.
Because it was appearing.
Give the numbers, give the
Or
numbers.
maybe permit to mention one motion matter from the monthly list, my lord. What happened, the petitioner was a leaseholder in respect of mining business. Subsequently, my lease was terminated prematurely. Now, my lord, in the meantime, they have served me a notice to deposit certain amount of money, my lord, on account of 44 lakhs, the bid amount, rest bid amount. My lord, what has happened, my lord, they have threatened and given me a letter respondents that they will initiate public demand recovery proceedings against me, my lord. I'm praying for upgradation of that matter, my lord. In the meantime, they may start in, it's in the monthly list, my lord. I'm grateful.
My lord,
Last week, my lord, still asked me to come back today. It's regarding reallocation of allotment in favor of my client. It's a Salt Lake property. Everything has been done despite of which, my lord, the allocation.
Give the number. Give the number, please.
Content application for inclusion.
Contempt application.
I'm mentioning.
Contempt application.
Contempt application, please.
Content.
my lord, may I permit?
We contemplate.
Lord, this pertains to Lord sand mining matter, Lord. In any event, you lot to be submitted an order of Lord consideration, they will again throw me back here. Lord kindly takes up the matter pending for long. You lot should
Give the number. Give the number.
My lord, may I permit it to mention, my lord?
monthly list.
Give the number. Give
My
the
lord,
number.
may I permit-
Permit it to mention, my lord?
My-
That is upgradation from monthly list, item number 634, which was that lease has been taken, but they have not considered due to lockdown, that period has been ended. So kindly extension I required.
Give the number.
May I have your lordships?
They are permitted to mention item 672 of the monthly list. It was directed to appear on 2nd of August, but due to unavailability of the bench, the matter could not be taken up. My lord, I'm praying for upgradation in daily list. My lord, the issue was that the minor, at the time of, he was a minor, his land was acquired, but no compensation, no subsequent land has been given or in alternative land, though the award was there. Thereafter, they were relying on a notification for which your lordship sought for a clarification, which was supposed to be given on 5th of July. Thereafter, they short time and fixed on 2nd of August. But it was, the bench was not available, but subsequently the matter has been posted in the monthly list. And praying for upgradation.
My lord, your lordship, may I be permission to mention, my lord? Your lordship, may.
Mention matters for a day.
My
May I have
lordship,
your lordships?
Mainly lordship, lordship
Yes.
kindly. Lordship, the matter.
8 February 2022. There are some persons, they are not the petitioner. They are filed big match number 19 of 2023. Applicant were not party to the petitioners. In the honorable division bench, that the applicant hearing should be heard by the single bench. I have all the orders ready.
My lord, my lord, may I be permitted to mention two matters, your lordship? Your lordship, my lord, may I be permitted to mention two matters?
My
your
lord,
lordship?
my lord, may I be permitted to mention, my lord, one.
But the matter is running in the monthly list. The matter is not coming in the list. The urgency is, lordship, the respondent authority is going to give the query permit to the third private respondents, your lordship.
Give the
Kindly.
number.
May I have your lordships kindly to mention?
Lordship, 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 may I permitted to mention one.
Permitted to mention one. E-mentioning, my lord. One e-mentioning.
Link to the.
Lordship, two hearing matters, lordship.
Urgency.
My lord,
My lord,
May I have your
Lordship,
lordships?
two hearing matters. Lordship, mention two hearing matters. The hearing has been commenced. Both are the similar matters, and such type of matters, similar matters, has been disposed of by the coordinate bench of this Honorable High Court. Only the law point is concerned for hearing. Only one law point is pending. And kindly fix the matter. Kindly fix the matter. Lordship, everything is complete.
my lord,
May I
may
mention an
permitted to
application,
mention this
Lordship, because your
mentioning,
Lordship's
my lord.
pleasure to direct us to file an application for substituted service on the private respondents. Lordship, this is that matter. If I'm
My
wrong,
lord.
May I have Lordship's
My lord,
kind brief, my lord?
Item number 850 of the monthly list, urgency is that initially unauthorized construction was raised upon the PWD land and encroaching my ingress and egress. Now the situation is they are rapidly developing the construction to hinder the entrance of my property. And the encroachment has been raised upon PWD land.
My lord, we have Lordship's kind brief, my lord, with regard to item number. My lord, with regard to item number
My lord,
166.
Yes. Yes, all applications, everything else tomorrow again.
My lord,
Lordship,
one
please.
My lord,
thing, my lord. With
mentioning,
regard
my
to
lord,
item number
mentioning item number
166, my
one,
lord, I
my
have some urgency.
Yes,
I tell your
yes.
Lordship what?
You can come back tomorrow. You can wait for
I
another
can
day.
come back, my lord, but some urgency, your Lordship, kindly upgrade it.
Tomorrow.
May I come back tomorrow, my lord?
Yes, tomorrow.
mentioning, my lord.
Yes, call the days list.
May permitted. May permit to for mentioning, my lord.
Tomorrow, sir.
My lord.
Matters have been taken up today. Yes, days list.
I am appearing for the alleged contender in this matter.
The petitioner.
Yes.
There was a direction for compliance, my lord. Order has been complied. I'm filing the
Yes,
affidavit.
complied.
Yes, the authority has passed an order, my lord. One thing, just my one humble submission is that the order has been passed. However, in the order of Honorable Justice Pratik Prakash Banerjee, as his lordship then was, there was in the order it was stated that, however, if the respondents have records which are unimpeachable and which show otherwise, respondent number 2 shall be entitled to take a decision in accordance with law, even if it is against the interest of the petitioner. So that was one portion of the order that I read. So my humble submission is that, my lord, this portion has not been reflected in the order that has been passed. That is the unimpeachable records that portion has not been reflected. However, it's true that the authority have passed an order. We were duly communicated last Friday. So that part I won't deny. So, but
Well,
this is my humble submission.
I have the affidavit of compliance, my lord.
Yes, so substantially complied. with
Complied.
it.
My
If
lord,
you're ready, you have a separate cause of action.
Yes.
my lord, the affidavit
That's
has not been formed, my lord, because we got it on Friday night, my lord. I'll get it done right now, my lord.
Not today.
My lord, within the course of the day, I will file, my lord.
No, no. Come back now. Tomorrow.
My lord, great.
Not today. Not today.
For the contender first.
Applicant?
As a review application, the both 2 and 4, but as I supply the number today. I got the certificate copy. I opened in the department.
My lord, if the review
Well,
file, my lord, and if it allowed, my lord, his content has not.
But that after hearing the review application, then that has been kept pending only for the purpose of, because in the contempt posted, the learned friend, my lord, the contemptor stated the respondent of 5 is not the authority to pay to consider the application to pay the compensation as per direct purchase policy. For that reason, you will also give me liberty to file a review application so that in place of respondent of 5, that will be direction is to be given to the respondent. That's a collector respondent number 2. So for that reason, then we file the review application. Now let the review appear before the lordship answer.
Yes, the review application number.
But I'm giving the review application number 191 and 92. I give you the number, Mola.
Have you received a
191 and 192. 2 and 4 are same.
2 and 4?
2 and 4.
Review application আছে এটাতে।
Just Friday it has been filed. Just Friday.
Oh, Friday you have filed.
Right.
The review application is not in the file. Paragraph, the department is directed to put up the review application along with the file on the adjourned date. Paragraph, let the matter appear under the same heading on
What date may be given, my lord? Because
Yes,
have
again.
any objection?
That is our lordship, my lord.
5th September.
5th September. Okay.
2 and 4, same order.
Yes, yes. Leave 2 and 4. 2 and 4.
2 and 4. কোনো width নেই এখানে। I'll call one by one. It's different. এখানে রিভিউ নাম্বার নেই কোথাও, আমি তো জানি না রিভিউ নাম্বার। উনি যা দিচ্ছেন তাই আমি এখানে নোট করে নিচ্ছি।
Oh, 2 and 3. That's 2
Yes,
and 3. 2 and 3.
2 and 3.
2 and 3.
3 CPN 660.
প্রথমে এই এডিশন দেখি না। This is 2 and 3.
2 and 3, same order.
Same one.
Lordship, I am for the please.
My lord, this is the compliance report, my lord, already.
Give a
compliant.
copy. Lordship, in this matter, Lordship directed on 16th November 2021 to implement the order of the labor court by initiating a proceeding of recovery within a month. Now, almost 2 years, well, first contemptor filed a compliance report stating that office was in dark.
Yes.
After having a copy of the contempt application, they came, his office came to know the order passed by the honorable court. Thereafter, he stated on oath that he closed the file by sending a report to the government for issuance of certificate. He transferred. Your lordship granted an opportunity to me to add the new incumbent as a party. I added the successor of the my lord, I filed an affidavit of service. My lord, now he is filing an affidavit. My lord, I kindly allow me to. My lord, there is no case number and date of filing complaint before the magistrate. My lord, when complaint has been filed before the learned magistrate, there is nothing in the affidavit. It is the duty of the recovery officer to recover the amount, thereafter close the file.
No, my lord, paragraph number 3. My lord, kindly have a look the paragraph number 3.
Yes.
Hey,
This is your complaints.
No, not my complaints. What my learned senior friend is saying, this is the complaint which was filed on the case number. Is all here.
Have you made over a copy to
Lordship remembers on the previous occasion, I had wanted to hand it over, but since I am not presently posted therein, Lordship did not permit me. As such, he was added. But Lordship, I can certainly give him a copy.
What is this?
Complaint to copy. যার মধ্যে কেস নাম্বার লেখা আছে
ওটা
যেটা দিতে চাইছিলাম আগের দিনকে সেটাই
কি কমপ্লেন্ট ফাইল করুন who filed the complaint contempt number 2 or contempt number 1
I have filed on behalf of the
he
contempt.
is appearing on behalf of the contempt number 1
that's why Lordship did not permit me to file this, but since this dispute is cropping up, Lordship, I am handing over this copy.
give me a copy Lordship, Lordship, first affidavit
has been filed before the ACJM Bidhan Nagar.
that is there, this is not in the affidavit.
Yes, my lord. Why, my lord? My lord, kindly paragraph number 3, my lord. I have details, my lord.
The number.
Number and date of filing, so that workman engage and advocate de facto
You
complaint.
have only said that you have filed.
File.
You have not given any detail of the
My lord, case
complaint.
number being case number, my lord, middle portion of the page number 3, my lord.
See, 2771
My lord, being case
of
2023.
Where is it? At page
Yes,
number?
yes, my lord, that is there.
Page number?
Page number 3, my lord.
My lord, that is
In my compliance of the report, my lord.
on 7th July,
Middle portion.
7/7/23 being case number C.
Oh, 2771 of 2023.
Yeah.
So the number is there.
Yes, my lord.
So
Number is
compliance-
there. Now, I have to
Yes.
pursue the matter by engaging
Then,
de facto
may I hand
complaint.
him over the copy. He will be needing it more.
No, I want
Silence though.
only case number and date of filing. Case number and date of filing. not getting more.
Affidavit of
And
compliance.
after lapse of 2 years,
Submitted on behalf
that
of the second contemner is taken on record. Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPA and such and such is disposed of. Paragraph, there shall however be no order as to cause, Sergeant Certificate website copy.
my lord.
Maybe not.
Yes.
And on compliance of your lordship's own order, my lord.
Is it appealing for the
Regarding
first time?
compensation, first time.
Will you serve and come back?
Yes, yes. Regarding compensation, I'm a DM, Alipur choice for us.
The applicants petitioners are directed to serve copy of the contempt application along with her.
My lord,
12th September,
my lord,
12th September.
get full loss, my lord, get full loss. Get full loss. My lord's order, basic order is there to pay compensation, but nothing has been paid.
Please serve and come back.
Yes, yes, get full loss.
Item 6, my lord, I am for the petitioner. My lord, my service prepared, but it has not yet affirmed. My lord, only state respondent. My lord,
So there is appearing.
my lord, here, my lord, my pro-grandfather, my lord, took lease, my lord, HON'BLE property for a period of 1999 years, which is still existing. My lord, lordship, kindly turn to page 22 first. My lord, according to my lord rules, my lord, the authority concerned, my lord, issued bill for my lord, the lease tax, and my lord, we will pay the same. The last pay, my lord, 2012. Lordship, kindly see page 22.
Yes.
Thereafter, my lord, page 24 to 27. My lord, different times, my lord, different legal layers of the original lessee, my lord, made representation to the authority concerned. Please send the bill and we will pay the tax. No action was taken. Lastly, my lord, kindly turn to page 28. My lord, this bill sent, my lord, 43,23,454. This is, my lord, 100 times tax, my lord, they have extended. My lord, we made a representation on one of the legal layers. Lordship, kindly the next page, page 29.
Yes.
Kindly consider it because 100 times, 100% tax has been increased, my lord. Thereafter, my lord, lordship, kindly turn to another representation made page 30, 31, 31 page P10, my lord. My lord, to the secretary, to the my lord, senior special secretary. My lord, he is the higher authority for which since my lord, he is not taking any action. My lord, we made a representation to the next page 33. My lord, this is, my lord, issued by the my lord, respondent number 3. That is the additional my lord, district magistrate. That if you will not pay the same, my lord, our lease will be terminated. So, my lord, my submission that the tax which is, my lord, enhanced 100%, my lord, it is, my lord, I am asking myself, my lord, is it believable? So, my lord, do you want a hearing? So, my lord, my submission before your lordship, my lord, kindly direct the, my lord, the senior officer, that is, my lord, senior special secretary.
And because my lord, notice was issued by 28 by the ADM, how the senior officer will do this?
Because he, my lord, this is my, we also made representation to the.
Let page 29 representation be considered by
My
the
lord.
by the ADM.
My lord. And my lord, in the meantime, the impugned notice, my lord,
State.
my lord.
Pending disposal. Yes. Till disposal. Disposal. Yes. Yes. It is contended on behalf of the petitioner that the pro-grandfather, PRO, pro-grandfather of the petitioner, Sheikh Sajjad Karim, comma, since deceased, comma, was granted lease in respect of Khas Mahal property in holding number 3259.
My lord, I am coming. Do number.
Hyphen, it's a 3-2
My lord,
hyphen
holding
59.
number, my lord. CC holding number 3-2-59.
At CC holding number 3-2-59 at 39/2 Canal East Road, comma, Kolkata 7,11,000, comprising an area of 9K,
9 kata, 4 chotak, 30 square feet.
14 chotaks, 30 square feet from the respondents for a period of 90 years, 90 years at a yearly rent of rupees 578.12 paisa by virtue of an agreement for lease executed by and between the parties on 19th November 1953. Stop. The lessee, during his lifetime and thereafter the legal heirs of the lessee, including the petitioner, have been paying rents, paid rents for the leasehold property till
It is paid up to 18 November 211, page 23. Last bill
you have
tax paid.
stated till 2012 you have paid.
My lord, up to from 12, my lord, we are seeking to deposit the
Till November. This was received in January 2012.
My lord, yes, this is received on January 2012, but the tax was paid up to 18 November 2011.
Till 18th November 2011. Stop. Thereafter, comma, the petitioner and other legal heirs, comma, by several communications, comma, requested the authority to accept rents/tax from them, but to no effect. Stop. By a letter issued on 17th February 2022, comma, the additional district magistrate and district land and land reforms officer, comma, 24 Parganas South, comma, Alipur, comma, being the third respondent herein, comma, issued notice upon the petitioner and others and other legal heirs demanding an amount of rupees 43,23,454 as rent along with interest, which is the interest stop dealing. Stop. The petitioner submitted a representation before the concerned authority on 8th March 2022 requesting review of the demand and waiver of penalty. Stop. The representation is yet to be considered. Stop. The third respondent issued a further demand notice upon the petitioner and others on 18th July 2023, requesting payment of the amount due failing which the lease was under threat of termination. Paragraph. The petitioner seeks a direction upon the authority to consider the representation submitted by him and further prays for stay of the notice dated 18th July 2023 in the meantime. Paragraph. Learned counsel for the respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month, within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. The notice dated 18th July 2023 shall remain stayed till disposal of the representation.
My lord, after disposal, at least, my lord, after getting the order.
7 days.
7 days, after getting the order.
Shall remain stayed for a period of 7 days after receipt of the order.
My lord, deeply obliged. My lord, I undertake to file the affidavit of
Please do.
service in course of this demand.
I'm appearing for the petitioner, my lord. ওই তো ওখানে দাঁড়িয়ে কিছু আসে যায় না I am challenging
Service.
yes everyone is appearing I am challenging series of orders passed under section 10(4) of the act. The allegations, the demolition proceeding is today. Everything is there. They are about to start the demolition, waiting for your lordship's determination. 3 points that I'll be agitating before your lordship. First is point of jurisdiction of the highway authorities. My humble submission in this would be that this particular land where the demolition proceedings is being carried on is a government land. Now, in view of the fact that this is a government land, the Highway Authorities Act will not be assuming jurisdiction. It has to be done under this eviction of 62 Act. First. Second is orders passed without considering any material, without giving any reason, and without supplying us the copies or the materials on the basis of which the orders under 10(3) and 10(4) have been passed. That is violation of principles of natural justice.
10(3), you were not given an opportunity of hearing.
Yes. We were there. We participated. It is recorded that without prejudice to your rights and contentions with regard to the jurisdiction of the highway authorities, we participated. There were previous proceedings also, not these writ petitioners, because these are all arising out of an orders passed in the public interest litigation, which was subject matter of challenge also before your lordship. We had in other set of writ petitions, they had challenged the 10(3) notices before your lordship. Your lordship was pleased not to interfere and dismiss the writ petition. It was carried up in appeal. The honorable division bench interfered, and in a similar sets of matters said that this has to be disposed of individually, individual hearing done, and individually it has to be disposed of. So third point would be that this order of the honorable division bench, which was passed in identical matters, I am not saying that those writ petitioners and these writ petitioners were the same. They were not. So the inference, the logic which was laid down by the honorable division bench that there has to be an individual order and there has to be an individual consideration of the representation, that has also not been done. So basically 3 points. I'll be first drawing your lordship's kind attention to the record of rights as to where this proceedings is being carried on. It is at page 47. This is to substantiate that this would be government land and it will be under the 62 Act. Kindly comes to page 47. These are similar, so therefore I'll be drawing your lordship's kind attention to the records of one case. This is, my lord, plot number 122/721. Lordship is there at page 47.
Give me a minute, please. Who is appearing for the private respondents?
My lord, learned senior
Respondent
apprentice.
number 12 and 13, my lord.
They are the public
Here-
interest litigants.
My lord, I have just received the brief just precisely 3
13.
minutes ago.
What about the others? Served?
Yes, yes.
All the
Everyone,
private
sir. Everyone, sir.
My lord, here the government's, my lord, it has a checkered history.
Where is the service?
Hand service, my lord.
Yes,
Hand service, my lord.
to the private respondents.
The learned advocate for the private.
Hand service to the private respondents. How is that possible?
Advocate to the advocate of the private respondent.
He is
No,
appearing
so
for 2 of them only.
No, no, not
This
for
is a fresh
not for all, not for all, because the public interest
Served
litigation.
come back, sir.
In any case, my lord, I have
I
paid for
will-
dispensation of service of my lord 26, rule 26. I have a case that I can make out that even if it is not served, I can, because as of today, the private respondents they have brought it to the notice of the honorable
order
division.
impugn.
Yes.
Yes.
Sure.
Order impugned would be
Because
at
the
page
matter is
49.
heard in presence of the private respondents.
My lord, my humble submission would be in these cases where the private respondents are litigants in a public interest litigation. They are not losing any private right. They have brought it to the notice of the honorable division bench that there has been waterlogging in the place. So therefore, on that proceedings, the honorable division bench had observed that if there is any illegal occupants, that has to be removed. Pursuant to that observations, 10.3, 10.4 initiated, and we are now before your lordship in 10.4. Page 49 is the 10.4. I would be also drawing your lordship's kind attention to the 10.3 also. Page 49 is totally non-speaking. The order dated 19/7/2023 kindly skips over 1, 2, 3, 4 paragraphs and starts from the consideration.
Yes.
4 paragraphs are what have been submitted, where this is being done. These are the things. Lordship Minle kindly sees the 3rd paragraph. The land is mentioned, dag number 122/721. That is the dag, which I say is a government premises. I have documents to substantiate. Since your lordship wanted to come to the impugned order first, I'm placing.
This is only for one of the appellants, isn't it?
It's my lord, in respect of many. It will appear from the order itself. Peruse the records, and it appears that the appellant encroached 8 feet into 24 feet is equal to such and such square feet of PWD land. How? Nothing mentioned. Considering the submissions made by all the parties and after considering all relevant documents in this case, being the district magistrate, South 24 Parganas, I am of the opinion that the present appellant had made unauthorized structure over PWD land, which is illegal, and that it is liable to be removed. Therefore, the prayer of the appellant is hereby considered and disallowed. The order dated 9/5/2023 passed by the executive magistrate Diamond Harbour is upheld. The executive engineer such and such is hereby directed to take necessary action as per law. Thus, the appeal proceedings is hereby disposed of. This order shall take immediate effect. All concerns shall be informed accordingly. Now, your lordship kindly sees here he has not disclosed anything basically. What are the records that he has perused? What were the considerations that was going into his mind? Why he has held and why he has not held in my favor? This is a totally non-speaking order. And if there are records, I am entitled to the copy of the reports. It has to be recorded that these copies of the records have been submitted, supplied, circulated, inspected. Minimum compliance with the principles of natural justice.
Now, since the
Not done.
respondents are not ready today, I cannot take up the
State
matter.
respondent is there. State
I also
respondent.
not
State
given
is the authority.
Yes.
State
instruction
is the
recorded-
authority.
Instruction is recorded in this matter because their allegation is that whether the land is government land or my lord PW.
That
land,
is page
all that
47.
that
I
will
can
acknowledge
substantiate.
So let this order, and this order is in respect of only one, the
Eh,
first.
Several, that your lordship would see from the,
Petition, your lordship will kindly appreciate.
kindly comes to
The
page
honorable-
43.
My learned friend is submitting that individual orders are there, individual case, individual representation, and the petition is on the other hand has been forwarded jointly.
That I'll show why jointly. I will show.
Consider this aspect. And my,
43 is 10-3.
Yes, kindly see 10-3.
Challenging the 10-4 order, isn't it?
Obviously, 10-3 has now merged into 10-4. Everything is under challenge.
19th July order.
Yes, if I challenge this, entire thing is challenged because it has merged.
One petitioner only.
No, kindly comes to page 43. There are several petitioners. In 43, your lordship would find that 10-3 orders,
Appeal was filed by one.
many,
All of them.
many appeal, all copy paste orders kindly comes to page 43. Your lordship would see 10-3 was in respect of several.
Yes.
Kindly comes to page 44 on careful considerations of this chairman.
served upon my lord individual. I can here and now, my lord, so from my.
It is
name,
there. It is, I have
because
annexed. He doesn't
intimated
need to show. That is what I'm trying to substantiate.
Without spending more time on this today,
Hmm.
please serve.
But the demolition is today. They are there.
Stay this order, sir.
My lord.
My lord, your lordship kindly appreciate.
Let me stay this order till the adjourned date. Let
Till the
service
adjourned
be
date,
completed
in any
and hear
case.
it out on the next day.
Once it is stayed, your lordship kindly bear with me 2-3 minutes, then it's entirely up to my lord. My lord, an entire area of a stretch of 3 kilometers area, my lord, along with the residents, my lord, were submerged. Then, my lord, the public interest litigation was filed. My lord, ultimately the situation so became so grave, my lord, that under the order of the division bench presided over by my lord Justice Sanjeev Banerjee, my lord, to engage 60 pumps, my lord, to combat with the situation. And my lord, there are some strictures and orders upon the state government also. Thereafter, my lord, direction was there for measurement and to see who are the encroacher, who has stopped. A canal also, my lord, have been filled out. Hundreds of notices are there, everyone is there. And now, my lord, it's practically a philanthropy. Your lordship will kindly see at least 4 writ petitions were moved on this on that text. In one petition, my lord Justice Anirudh Durai, my lord, since it was my lord a joint petition, my lord was pleased to direct my lord to submit individual stamp duty. They didn't proceed any further. The matter is kept as such. Another matter was moved ex parte, my lord, before my lord Justice Vivek Chaudhary.
Anirudh Rai, my lord, we have not moved.
My lord, in view of the order passed by the court number 1, my lord, in public interest litigation was pleased not to entertain the writ petition. There against my lord, an appeal was carried out. And in the appeal court, my lord, presided over by my lord Justice Arijit Banerjee, my lord, certain directions were given. Because they were submitting, they were not served with notice. That was their plea. I produced that the notices under section 10-2, 10-3, everything has been given.
No.
Then, yes, I can.
Specifically, I can show it from the order itself.
Yes. Then
Please
my
don't
lord,
make any submission which is not
they are
contrary to the
also
record.
pleased to direct that on that basis they will go, they will make their submission. They appeared before the authority, they make their submission. There was nothing prevented them to make any written submission to that effect. Then, my lord, an order was passed. Then an appeal was carried to the district magistrate. District magistrate, my lord, after considering the entire order, my lord, entire aspect of the matter was pleased to direct my lord to dispose. Admitted position, my lord, under whatever act it might be. I'm not on that. Admitted position, they are the encroacher. And my lord, yesterday itself, the Honorable Supreme Court in a bench presided over by Justice Anindya Bose and Justice Bila Trivedi has been directed the encroachers do not have any right. And the matter is supposed to be finally dealt with, my lord, today itself. I can produce if my lord give some time, my lord, I can produce that order also. That interim order was no more extended. Your lordship will have to consider whether, my lord, under such circumstances for a handful number of persons, the entire locality, the people of the entire locality will suffer. Your lordship will have to consider this aspect also.
The state
Because the
needs
entire.
to take instructions on this. State is
Yes.
not ready today.
Yes, my lord.
It is for the state to make these submissions.
Yes, my lord, your lordship, without staying the order, what I am submitting subject to my lord's kind consideration. My lord, kindly direct, even if it is there, if they can substantiate their right, that there was infringement,
that their fundamental right was infringed, that their legal right was infringed, that their statutory right was infringed. My lord can say
The
that not in
primary
their
question
aspect.
is with regard to jurisdiction.
No, question of jurisdiction, it was
Whether
there.
the-
This is no more there in their hands. The question of jurisdiction at this stage, at this, after a series of litigations, they cannot take that jurisdiction.
No, we have taken it.
That point was available before court number 1. That point was available before court number 6. At this stage, my lord, question of jurisdiction
So
doesn't
the
arise.
matter needs an
Totally.
extensive hearing, come back on the adjourned date, let it be stayed. Yes, Mr. Bottomell?
Stress is also necessary, my lord. My lord, either way, they are the encroachers, my lord. Either government land or my lord, a PWD land, my lord. My lord, let the eviction proceedings may.
No land will
Southern
be
land,
recovered and the
under the
people of the
62 Act,
area will suffer.
Yes,
Would the district magistrate have passed this order?
But they have not, my lord,
Would it have been
submitted
dealt
this
with under
point.
Section 10 of the Highways Act? West
But
Bengal
kindly
Highways
see
Act?
page 49, they have not, my lord.
Page 43, we have specifically said.
49, my lord.
This first
But
forum, we have
submission-
specifically said
As
was
such
the
by the
submission,
appeal
my
court.
that this notice under section such and such is made without prejudice.
Instructions of
I
the
shall come back
legislature.
with the instruction, my
Let
lord.
this order be stayed till the next, till the adjourned date. It has to be given an extensive hearing. And please serve in the meantime. I will
Yes,
not take
yes.
up the matter without service upon all.
Yes,
And
yes.
then the, my lord, the court, order passed by court number 6 will be diluted.
No, no,
This,
no,
this question was there
no,
because they were directed. They didn't raise any objection. They didn't move higher up.
no, no.
On the basis of those notices, your lords, kindly consider the order passed by the appeal court. Court number 6.
In a different matter.
Yes,
In
my
a
lord.
different matter, different
No,
sets of
not in
repetitions.
different matter. In their respect of same.
No, no.
local- my lord,
Locality.
50 persons were there. They cannot say, my lord, I have to then compare, my lord, with the other sets of litigation. It's practically, my lord, your lords will excuse me, it's practically a forum shopping. By
Please
placing some persons in the front line and the others are there. It's practically a forum shopping.
come back on the
And
adjourned date.
why this, my lord?
পাঁচ
And
দিনে
the
কি
order
আসবে যাবে দাদা?
is being frustrated.
5 দিনে কি
Your
আসবে?
lordship will kindly consider this aspect that the appeal court's order, your lordship, when my lord will pass, my lord.
This
has the
goes to
power
show
pass
that
an
he
order.
is not
But
in a
at the
bona
same
fide
time-
public interest litigation.
At
He is
the same
having,
time, my
he is
lord
having
will kindly
private rights.
What was the order? Whether they failed, they agreed or they have accepted it. The order passed by court number 6 in the appeal against the order passed by my lord on earlier occasion. Your lordship will have to consider this aspect of the matter. Even my lord, on earlier occasion when it was moved before my lord, the question of jurisdiction was not there.
Obviously,
Because
it's
the
totally
entire
there.
thing was there. They
They
did.
are challenged 10-3.
No, yes. The point was that the notices were issued, they have not been served within any notice. That was the reason. It's not so easy as my.
Notices were not issued. That is the point.
Consider the appeal court's order.
দেখা নিজেই দেখা।
Jurisdiction was challenged in 10-3.
Specific challenge.
No, my lord, this is, my lord, when the 10-3 notices were there, that notices were taken note of by the appeal court. Your lordship kindly appreciate the, why I am submitting. Your lordship kindly appreciate.
May I just content?
When notice under section 10-3 was given, that was there, that was placed before the appeal court.
Was this challenge raised before the appeal court?
No, that's why I am submitting, my lord. They could have, when they took up the appeal.
They are not the same petitioners.
My lord. They are, but it's not that they're the same petitioner.
They may
My
be
lord,
similarly circumstanced.
No,
but they are
not
the
only,
same.
not only that, if I can compare, my lord, I can produce, my lord, because I have got just now.
Please do that and come back. You are not ready, sir, today.
No, I am not ready in this sense, my lord. Then
Spending time
I
on
have
this.
to, my lord, show. Your lordship kindly see. Because those writ petitions are not here. Here, it is not there. Your lordship kindly see what was the representation before the executive magistrate at page 199, whether a question of jurisdiction was there or not. When the objection was raised.
It has been recorded in the order itself, my lord. Kindly see. Page 43 is the order. Quote unquote, it has been recorded. This is a notice being numbered such and such under section 10(2) of the West Bengal Highways Act. It is being made without prejudice to the rights and contentions and without waiving my right to challenge. Change it is not a challenge the jurisdiction, power and authority of the Highway Act to issue notice
That is there.
and going to the dispute.
The objection 199, there is a specific challenge. To
Yes, your
jurisdiction.
lordship now will kindly come to page 20.
20.
Are you ready for the hearing, sir? I'll
No,
take up the hearing in that
My
case.
lord, your lordship kindly
You
consider,
cannot,
my lord, this appeal court's order, my lord will kindly consider. Then thereafter, my lord will.
you cannot on one hand say that you're not ready and then make your submissions.
No,
in a
no,
piecemeal
because my lord, I
manner.
am submitting. Why? If it is stayed, your lordship will have.
Please stay for a limited period till the adjourned date. Please serve in the meantime and come
My
back.
lord,
Mr. Waterwell, please take specific
Yes, yes.
instructions and come back.
physical service.
You've heard the submissions, the
Yes.
jurisdictional issue and that they have not been given an opportunity.
Because the petitioners before the public interest litigation as the worst most sufferer.
Affidavit of
And they are the
service.
reaper of the fruit.
সবাই আচ্ছা আপনি তাদের অ্যাপ্লাই করলেন কতজনের জন্য বলুন?
আমি তো দুজনের জন্য দিয়েছি,
বলেছি রেসপন্ডেন্ট নাম্বার
ও 12-13 বোধহয় হবে।
12 and 13
হ্যাঁ, হ্যাঁ।
বাকিদেরকে দেবো।
বাকিদেরকে কর স্যার।
The order passed by the district magistrate South 24 Parganas under section 10(4) of the West Bengal Highways Act 1964 on 19th July 2023 is assailed in the writ petition. Stop. Paragraph, it is submitted on behalf of the writ petitioners that the demolition drive, DRIVE, is scheduled to take place this day in terms of the said order. Paragraph,
which will be appearing from the notice at page 232.
order,
432. Today's date. From 11, it should start.
order as appears, as appears from the notice issued by the authority on 21st August 2023. Stopped. Learned counsels for the state respondents. You are for 12 and 13.
Ranjit Haldar, my lord, and his wife. 12 and 13.
Learned counsels for the state respondents and respondent numbers 12 and 13 seek to take instructions in this matter. Stop. The other private respondents have not been served. Paragraph. Let the matter appear under the same heading on 12th September. 12th September, please be ready. It needs an extensive hearing. There are earlier orders. Paragraph. Affidavit of service be submitted on the adjourned date. Please ensure service, Mr. Lahiri, on
Yes,
the,
yes,
by the
yes.
adjourned date. Paragraph, the
My lord,
order impute.
would your lordship be kindly keep it on 13th because 12th September is a Tuesday. And my lord, I am being regularly appearing before the Honorable Supreme Court in a matter which is being taken up on every Tuesday.
So 13th you'll be back.
13th, yes.
13th September. The order impugned passed on 19th July 2023 be stayed till the adjourned date.
And my lord, the learned advocate appearing for the state respondent should communicate because the JCBs are there. They are about to start demolition, just they are waiting for. If he communicates, then only it will be done. Our communication will not be of much.
Last appears that the encroachers are so powerful that they could hold the JCBs.
Obviously, I have served. They are supposed to wait for the court when a matter has been filed.
Don't you think it's an irrelevant submission before the court, sir?
No, it's not.
I have served. The petition has been, they are supposed to.
You have to approve forum before. Yes, next matter.
Learned state government advocate may be
Mr. Waterman, please ensure compliance.
deeply obliged.
If your lordship kindly. If your lordship kindly sees the order dated 5/7/2019. This is the last position, my lord. May I?
A report was called for.
My lord.
my lord, nothing is done, my lord. May I propose for one thing, my lord? May I serve this, my lord, order once more?
That is necessary because I do not find anyone and it has
So,
come
that-
from some other bench.
That,
that will be
my lord,
released.
a direction may be given, my lord, to that effect.
Have you served the private respondents earlier?
My lord, everyone was served initially, my lord. I will, once again, I will serve, my lord. I will intimate them once again. And my lord, so far the state respondents are concerned, my lord, may I, my lord, indicate this order and my lord, serve once more, my lord.
Because
And-
Mr. Shen Gupta and Mr. Shubir Pal were there. I do
So I
not
will,
know
I will,
whether they're
I
still,
will intimate, my lord.
I do not know whether they're still in the panel.
Initially, everyone was served, my lord.
Mr. Shushuman Shen Gupta and Mr. Shubir Pal. To serve the GP's office.
My lord.
None appears for the respondents. Paragraph. Since there has been a change in the learned councils, change of learned councils in the state panel. Since there has been a change of learned councils in the state panel, comma, the petitioner is directed to serve fresh notice upon the office of the learned government pleader and file affidavit of
As
service
well
on
as
the
upon
urgent
the
date.
private respondents also, my lord.
Paragraph. The petitioner should also serve the private respondents afresh.
Initially, they were served also.
Then afresh and file affidavit of service on the agenda.
My lord,
Paragraph, let the matter, yes,
my lord, state may be directed to, my lord, go through this order, my lord.
please serve first because there may be a different panel.
My lord, there is an order to that effect. It will minimize the, my lord, time. My lord, your lordship kindly sees this order, my lord. They were directed to
I do
file a
not-
report.
Let me see if this is necessary at all. Let them come.
My lord.
Let the matter appear under the same heading on 14th September.
What is-
I appear for the petitioner, my lord, in this matter.
Yes.
Lord, on the last occasion, there was a direction to serve.
Instruction, lordship.
I have served, my lord. The friend is here, but
The appeal has been disposed of.
no, my lord.
There was an appeal pending before a
Yes,
division
lordship.
bench
Civil-
with regard to a similar issue.
My lord, I had requested by a letter, which is the subject matter of the affidavit of service, to be served upon me, that what is the subject matter of the appeal before the Supreme Court, but nothing, or the High Court for that matter, my lord.
Not Supreme Court, it's pending before a division bench of. this
Division
court.
bench.
My lord,
Already comes High Court,
my lord,
Calcutta.
my lord, particulars have now been provided.
No, I have given. Such matters have been pending.
1 minute, এটা তো ডিসপোজ অফ হয়ে গেছে।
No, no.
হ্যাঁ, ডিসপোজ অফ হয়ে গেছে এটা। অলরেডি অর্ডার হয়ে গেছে এতে।
My lord, may I
Ah,
place my
form
case,
is
my
there.
lord? My lord, may I place my case and also the
Covered by
orders,
the Supreme Court.
orders
On
also.
the earlier occasion, the matter was adjourned. because
Yes,
of the
lordship,
appeals pending.
due to pending lordship.
Yes.
This was-
My lord, this information was not shared to me before today. I am still not got a copy of what is pending.
You are for the petitioner.
My lord, I am for the
The
petition.
same submission was made in your presence on the earlier date.
Earlier date, lordship, I have.
My lord, I had asked for copies, my lord. Man, beg to submit, my lord. That is the subject.
Give the details of the appeal.
Lordship, lordship, the date may be fixed and I will submit
covered
lordship.
আছে।
My lord,
Lordship.
Matter is covered by the Supreme Court.
This
My
is
lord-
your document.
uh,
The appeal numbers are stated here.
no, my lord, I believe he has submitted this for the state. That's his instruction that he has submitted.
You are also submitted. Whether this matter is pending or not.
So
My
the
lord, may
decision of the writ
I beg your
petitioner will abide by the decision taken in the appeals actually.
Lordship.
My lord, may I also submit, my lord, I have orders of this High Court, my lord, division bench, which went up to the Supreme Court and the SLP was also rejected. My lord, I have got orders that copies were shared with my learned friends on the last occasion Friday. I've
Please
already.
wait for disposal of the appeals. I'll take up the matters after that because on the
Lordship.
same ground, it was the agenda on the earlier date. So
My
please
lord,
come
may I
back.
have a list of the matters that are pending, which my learned friend
Please give him
intends
the
to rely upon?
numbers of the appeals.
Lordship, I have given number, lordship, whether matter is pending or not, I will file the next date, lordship.
Very well.
My lord,
Lordship.
my lord, can I
I'll file
only
lordship, next date.
Why don't
one
you provide
indulgence,
us the
madam?
numbers of the appeals?
Yes, madam.
Lordship, I have stated lordship,
Mat number 1691.
Have you given a copy of this
13?
to
And-
Dr.
and-
Hostel?
No. I have. No, ঘর ছাড়িয়ে দিয়েছি। I have read. ঠিক আছে, I'll give you after. Lordship, kindly sir. আমি just করে দিয়ে দেবো।
আমি নোট করে দিয়ে দিচ্ছি, দাও একবার।
হ্যাঁ, নোট করে দিয়ে দিন। হ্যাঁ।
In view of the observation made in the order passed on 20th July 2023, comma,
আমার কাছে judgment আছে, but it is already disposed of. Misleading.
let the matter appear under the same heading.
My lord, one indulgence may I seek, my lord. My lord, I consider the judgments that he intends to, the state intends to rely upon. My lord, and may I come back and mention the matter that all these matters are no longer relevant on the basis of the,
কুসুম দেবীতে cover আছে, ওটা already
all the
disposed of.
matters are disposed of, my lord. But
It is misleading to the.
so far, on a,
Matters are disposed of, appeals are pending.
Appeals are pending, that's
You
why I
think the
understood it.
appeals are disposed of?
Yes. I am
Yes.
showing the judgment of the
From me.
Kusum Devi matter.
If that
It
be
is
so,
covered in
please
this
come-
judgment, all judgments have been disposed of.
this is the order of the division bench.
This is covered.
Covered. Pawan Agarwal is already disposed of. Even in Ajay Agarwal order, it will be recorded, it is disposed of.
ওটা কোথায় চলে?
এই তো Pawan Agarwal আছে এটা।
It has been relied upon, my lord, Pawan Agarwal.
এই তো relied আছে।
I don't
হ্যাঁ,
know.
এদেরকে দেওয়া হয়েছিল তো last week।
না,
Where
না,
to
না, I'm
find
not.
the numbers?
Same number.
Please, give the
Pawan
copies.
Email,
Kindly.
State of West Bengal versus Pawan Kumar Agarwal. My lord, this has been relied upon in the
Kusum Devi Agarwal.
Kusum Devi Agarwal judgment by
Appealed up to Supreme
by the
Court.
division bench of this court,
Number is
Appealed up
same.
to Supreme Court.
which was on 27th September
But it's
2018. Name of the party is the same, my lord.
Party's name?
In his instruction sheet, of course, my
No,
lord,
no.
the numbers would
No,
not.
No, no, same, the judgment already.
Yes,
covered.
yes.
The name is also
Please.
not the same. This is Kusum Agarwal.
This is Kusum Agarwal.
Please give me a copy. Which I have
Radha
copied.
My lord will
Can
can't,
you page second.
my lord
last
will
four-
kindly
last
turn to
four
the
line.
next page, my lord, of
Last
the
four line.
judgment of Kusum Agarwal.
Last but four.
Ma'am, from the bottom, one for the fourth matter, my lord.
বলেছি second page.
No, no. কোথায় আছে?
Reported there.
Pawan Kumar Agarwal, which is the state of West Bengal and others. This matter, my
আমার
lord, was
পেপারটা কিন্তু দিন না আমারটা। আমার কপিটা দিন, kindly. আমার কপিটা দিন, আমি মিলিয়ে নেবো। আমি তো আপনাকে যেটা দিলাম।
এটা দিয়েছি তো আপনাকে।
আরে দিচ্ছি আপনাকে, দাঁড়ান।
Can you
আমি
please
মিলিয়ে
come back
দিচ্ছি।
with the judgments of the next date?
my lord. We will.
Huh?
Ma'am,
Because from this, it cannot be made out. As
my lord,
whether all
since
these
we have
judgments
just
are disposed
received it,
of.
my lord, we will.
Please do that.
My lord.
If it is back, please come back with the judgments. If appeals are disposed of, this court has no predicament.
My lord, may we mention,
are
my lord,
misleading.
my lord will kindly record in my lord's order if we are considering the.
I'll fix the date.
My lord.
হ্যাঁ। Mislead করছি এরা কোর্টকে।
Comma, the matter is adjourned.
কোর্টকে mislead
Oh,
করছি।
let the matter appear under the same heading. On
I have no
আজয়
intention to mislead this court.
15th September,
earlier করে দাও।
My lord, if earlier it,
আচ্ছা,
if it is convenient for my lord, maybe earlier also,
very well, 11th September,
11th.
11th September.
Lordship.
Grateful, my lord.
Please come back with the judgments in the appeals.
My lord, only thing is, my lord,
It is covered in this.
my lord, the list that has been handed over to my lord, I am not having the privilege of getting a copy of the list or at least that portion of it. I had to copy it in haste
একটা দাও আমাকে।
right before my.
Please give him a copy of the list.
I'll give you.
I will get a photocopy done and I'll hand it back to you. Okay. That is, I'm grateful, my lord.
Supreme Court appealed.
My lord, back to
My
earlier.
10 my lord, I am appealing for the writ petition, my lord.
Behalf of the, my lord, Metro Rail Authority, my lord.
Yes.
My lord, today I am supposed to file one report.
Hmm.
The thing is that, my lord, I am filing it, my lord, I also giving a copy of the same to the other side, to the petitioner. Thing is that the person who is responsible for, my lord, giving instruction, now he has been suffering from dengue. And, my lord, I led by Mr. Bikash Ranjan Bhattacharya, my lord, kindly fix that in the next week, my lord, matter may be heard on merit. Let him go through the report and. দিয়েছো?
Copy দিয়েছি।
This is my lord.
You've received a copy of the report?
Yes, my lord, a copy has been given, my lord. May he consider the report and come back any day next week?
If not possible, I'll give you a date. Report submitted on behalf of the second respondent is taken on record. Paragraph, copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph, on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th September.
I'm grateful, my lord.
But I've been told Mr. Timin Born Shah is appealing for the petitioner. He's engaged in some other court. Possible. Not today. He's praying for not today.
Where is the service?
Service could affidavit service. Oh, it's in the brief. It's with him.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th September.
Grateful, my lord.
My application.
My lord, Mr. Talasi is on his way. He is coming. He was in some other court. He is coming. He's on his way.
I could address your lordship, a very short issue.
Have you served the private respondents?
Yes, my lord, your lordship had taken this matter up for consideration and there is an interim order. I'll just check that, no, lordship, give me a minute. But my junior says he doesn't have a copy. I haven't seen it, but he says it was served. Your lordship will have a look at. And the order dated April 21st, 2023. That's the injunction that I had, the interim protection. But with regard to service on the private respondent, I wouldn't know, my lord.
Because there are private respondents in this matter.
There are, yes. It was on his complaint that the entire process was set in motion.
Yes.
Look, may I only suggest this? It'll probably be wrong on my part to. Should I just serve and come back, you know, after 2 weeks or next week? No, I'll serve and come back. My junior says that the affidavit of service is on record and we had served it.
One of them is served, I find. They are.
And I won't trouble your lordship with this. I'll serve them again and come back. You know. Lordship keeps it any other day. I'll serve it in the meantime.
You've challenged the 10-3 proceeding.
Well, challenge the proceedings purportedly under 10-3, but the order says 10-2, which is the lordship records. Now, by way of a report, it's come that it is not 10-2, it is 10-3, but I'll show that the consideration has not been in terms of what 10-3 requires. More importantly, my lord, round 1 was the private respondent's writ petition, which led to an impugned order being passed under 10-1. Round 2 was my writ petition, by which the order under 10 was challenged. Your lordship said there's a provision under 10-3, go there. If Mr. Tale is going to agree to this, because I wanted to give a written submission there, which was not even taken on record. That entire thing can, even if it's in a time-bound manner, by written submission can be taken on record and a de novo hearing can be given. Because this incongruity, they will probably not be able to cure here. The order says it's an order under 10-2. By way of an affidavit, I don't think the state will be able to rectify that. They're saying it's an order under 10-3. But whether it is under 10-2, and that is what your lordship has been pleased to record in that order. My lord's first order of April. So if they agree in a time-bound way, I can also place all my documents. Because this is a slightly complex issue. My lord, this jurisdiction will have to be decided by them. They've just come ahead and said that you have, apparently, I have gone and admitted this is an unauthorized construction. Now, whether this is at all a highway is something that will have to be considered by them. The 10-3 authority passing an order under 10-2, calling it 10-3, there is no reflection of that. And that is the representation that they don't allow me to file. That was with me. My specific case is they did not allow me to file. Let this 10-3 hearing be given again in terms of your lordship last order. If he opposes this, then I'll serve the private respondents and come and trouble your lordship on the aspect of jurisdiction. The cornerstone of.
My lord,
It's a hearing.
my lord, the entire intention of the petitioner is to procrastinate the.
Very
entire-
well, I'll
my lord,
serve and come back.
my lord, if your lordship looks at the sequence of all the orders, my lord, your lordship's last order, which is of 21st of November 2022 in the earlier writ petition, lordship directed us to.
No, let him not
my lord,
hijack
conclude
my
the
hearing.
proce-
Let
conclude
him
the
not
proceeding.
hijack my hearing.
I'll just take 2 minutes. I'll just take 2 minutes of your valuable.
Toma, 2 minutes.
My lord, lordship directed, my lord, the authority concerned to conclude the proceeding under section 10(3). We passed an order. There was an error. 10(2) was written. We issued a corrigendum saying instead of 10(2), it should be 10(3). It should be read as 10(3). And from the reading of the entire order, my lord, it is crystal clear that it is 10(3). My lord, my learned friend.
Very well. No, I will not argue.
Would
Very well.
appreciate, my lord, everything, my lord, is
No,
there
very well.
on record.
I will give up that
And in
point.
compliance of a
I
lordship.
will give up that point. I will not argue that point. I'll argue elsewhere.
10-3 order.
The 10(3) order is at page
38.
38.
35 it starts, Yes, 35.
38 is the relevant page.
38. This is apparently their order pursuant to your lordship's direction. I'll give up the point of 10 to 10(3).
In the head note, my lord, if your lordship sees,
I'll
MP 10
no,
sub-rule 2.
I'll give up that point. I won't argue that point. I'm telling this court. But if this is his order, my lord, I'll serve the private respondent, come back and then let them justify this. Except respond number 4, hard on mighty, that's not me. All other parties in hearing represented by the learned advocate. The opposite parties, including de facto complainant, have agreed, except respond number 4, who was continuously absent from last date towards, that PWD land has been encroached by them. Hence, all the opposite parties, including the de facto complainant, are given 2 weeks' time to remove the encroachment over the concerned plot. If not removed, PWD roads, encroachment over concerned plot, and so on. Lord, your lordship's order, that first order apparently under 10(1), we had challenged by way of a writ petition. Lord, we'll be wasting your lordship's time twice over. I might as well just serve and come back. Lord, if this is the consideration.
So Siddiqui, where is the consideration of
That's
evidence
right.
in
Lordship
10(3)?
looks at the entire orders.
The final order has to be a speaking order.
It has to be a statute.
Where is it?
That's why I said I'll give up the point of 10 to 10(3). How did he justify this in a
10
court
to
of law?
10 is technical.
It's technical. That's why I'm saying I'll give it up.
That corrigendum has been made.
I'll
so
give it up.
that's
I
over.
don't want. But how do they justify this in a court of law? When your lordship directs you to, there has to be a consideration. Where is the consideration? Your lordships have laid down what consideration as a term means in law. These 4 lines.
Now,
I'll place your lordship's order. And in fact, your lordship was so conscious of what 10(3) envisages that when we challenged 10(1), your lordship said that the law gives you that same consideration, that 10(3), you go there. I'll show that order. Page 44, no?
The earlier orders were at page 35. The lordship kindly sees. Starts from page 35.
I'll first let me show to your lordship my lord's order.
Page 35, yes.
35. It was found that it is the highway, and in the highway there is an encroachment.
No, my lord, that's not the consideration. Kindly have a look at page 44.
The evidence taken from by the
The petitioner did not turn up, my lord.
No, that was not
Despite
me.
his notice, my
No,
lord.
no,
Except respondent, if your lordship kindly sees page 38, except respondent number 4, all other parties in hearing represented by
34, 38.
38.
So I am not respondent number 4. Respondent number 4 is some Shahadev Bagh.
Haradan Maiti.
কোথায় পাচ্ছ? I'm 7.
Oh, you are 7.
I'm 7. That was not me. Atul Krishna Jana is 9.
Just a one line on
lordship may
upon
kindly remand
consideration,
back.
I'm satisfied of the encroachment.
My lord, your lordship may kindly remand back the matter to the authority concerned, but my
Let
lord,
the 10(3) be reconsidered.
That's all.
but your lordship may kindly, my lord, they should not seek any, my lord, adjournment before the authority concerned.
Well,
Because this
let
matter is
the
being- my lord,
authority
since
not behave like it is some privileged litigant. It is in folly of your lordship's order. The law requires them to consider a few things. 10.3, there are tests. It is as good as 10.1.
For 10-1 and 10-2 stage we have crossed. Thereafter, your
Correct.
lordship's order is there.
I agree. But the test
We have-
is the
we have
same.
crossed that
We are
stage.
only on 10.
I'm only on 10.3, but lordship,
10.3 is not a speaking order at all.
Abandoned, your lordship. Lordship may kindly remind.
which is why I said that I'll give up the point of
In
10.2.
his usual fairness, he'll agree
Correct.
that this is not at all a speaking order.
Lordship will allow me to bring on record the evidence that I have there, my lord, and sets it and puts it in a time-bound manner. Whatever I have,
You've challenged the
Granted,
28th
adequate
June order. What is the 28th June order? You've challenged that order.
10.1.
10-1.
28 June is 10.1.
So you've challenged 10-1. Please come to your prayers. P5, P6.
No, your lordship will have a look at. I've prayed, no, prayer E also, your lordship is right, my lord. But prayer E, your lordship will find certiorari is 5/1/2023 at page 20. The order at page, which is under, purportedly under 10.3 is 5/1/2023, prayer E. For specific prayer of certiorari for quashing of the same.
28 June is the 10-1 order.
Correct. I'm not on that. In fact, mandamus of all other orders also passed. But there's a specific prayer for setting aside of this order. Lord, there are certain checks and balances that your lordship had provided to the petitioner while my lord's order at page 44. Kindly keep that also alive, my lord. Because my 28 June 2022 order, the consideration was going to be under 10.3 in terms of your lordship's order of page 44. Kindly keep that also alive, that aspect of it. It can just be simpliciter, set aside and directed to be considered in terms of your lordship's order at page 44. I think that both Mr.
Not
Siddiqui and
necessarily.
I,
Give you an opportunity of hearing.
very well.
Place
It
your
was there in,
evidence.
it was there in your lordship's earlier order also.
It was there in terms of your lordship's earlier order. So both Mr. Siddiqui and I should be okay with.
So, Tale.
Oh, sorry.
May I take your lordship's leave, my lord? I'm grateful.
Yes. The petitioner,
Lord, may I also take your lordship's kindness? Sorry.
primarily assails the order passed by the executive magistrate, Haldia, on 5th January 2023, which is in substance, an order under section 10(3) of the West Bengal Highways Act 1964. Stop. The petitioner seeks reconsideration under section 10(3) of the Act in terms of an earlier order passed by this court on 21st November 2022 in WPA 24392 of 2022. Stop. The relevant portion of the said order is set out, page 44. I think the last line of the order is missing in this page. Do you have a copy?
My lord, yes, 44, my lord.
Please, the last line is upon opportunity of hearing to all the interested parties then.
Page 45,
Page 44, last line.
last line. All interested.
What is the last line in page 44?
The reasonable opportunity of hearing to all the interested parties.
Then there should be some other line as adducing evidence.
Hey, my lord, within 2 months from the date of publication of
This
this
is
order.
discontinued. There should be something else in between. I think a line is missing.
Kindly
কেটে দিন, এটা দরকার নেই। কি বললাম বলুন তো? না, এটা দরকার নেই, কেটে দিন। ওই ইন টার্মস অফ দ্য অর্ডার থেকে কেটে দিন। ইন টার্মস থেকে কেটে দিন। ওখানে করে upon being granted an opportunity of hearing by the authority. Paragraph. Passing the order. Paragraph. Upon consideration of the submission made on behalf of the parties, comma.
Yes, my lord, the missing line is after interested parties, including the petitioner and the private respondent as well. I'm sorry. my lord.
There should be something. Anyway, I'm just passing a fresh order. I'm not referring to that order at all.
Great.
One or two lines must be missing.
One line
because,
is missing.
it's
My lord,
not
I've seen-
connected.
from the server copy, I'm seeing that one line is missing.
দরকার নেই, আমি ফ্রেশ করে দিচ্ছি।
কি বলবো?
কি বললাম last time? Comma, this court is inclined to hold that the concerned authority should be directed to revisit the issue under section 10(3) of the Act of 1964 in accordance with law. Paragraph, therefore, the order dated 5th January 2023 passed by the executive magistrate, comma, Holdia in MP case number 1948 of 2022 is set aside. Paragraph, the concerned authority being the, should be the executive magistrate.
Not executive magistrate.
Not included as a party. And you're asking for a reconsideration.
No, my lord.
Will you add him?
My lord,
That
is ask me leave and that.
Being the executive magistrate, comma, Holdia is directed to revisit the issue upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, and pass a reasoned and speaking order within 1 month from the date of communication of this order. Paragraph, the parties shall be at liberty to adduce evidence, comma, both oral and documentary, comma, before the authority at the time of hearing.
Yeah.
No coercive step be taken against the petitioner in respect of the plot in question till disposal of the proceeding. Proceeding under section 10(3) of the Act of 1964. Disposed of, ওই চারটে লাইন একদম শুরুতে করুন, on prayer of the petitioner, liberty is granted to implead the executive magistrate, comma, Holdia as respondent number 7. 7 কি direction দিলাম তো? 7 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Please do the necessary corrections.
Great.
Next.
In this letter, I appear for the petitioner. The petitioner, an absolute owner of land. Without knowledge to the petitioner, the land, the possession of the land was taken by the state authority.
Taken by the?
State authority. When the petitioner came to know that the possession has been taken by the, in that event, the petitioner made representation before the authority to get back to return the possession of the land to the petitioner. Several representations were made before the authority. But subsequently, being agreed, the petitioner preferred a petition. The said petition was given up for hearing before your lordship.
Your microphone is switched off, I think. Please switch it on.
And your lordship was pleased to dispose of the petition with a direction to the respondent number 3, the special land acquisition officer Howrah, to hear the representation to be made by the petitioner and to pass an order. Accordingly, my lord, kindly see, my lord, the annexed kindly, your lordship kindly come at annexed P9, my lord, at page 47, ordering portion. This order passed by your lordship.
Yes.
My lord, may I read, my lord?
Yes.
Third paragraph. Upon consideration of the submission made by the learned counsel appearing on behalf of the parties and the materials on record, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievances before the respondent number 3 within fortnight from date. The third respondent is directed to consider the disposal of the representation within 2 months from the date of receipt thereof, after affording reasonable opportunity of hearing to all the affected parties, including the petitioner, in accordance with law. The decision taken by the authorities shall be communicated to the petitioner within a week thereof. It is made clear that this court has not gone into the merits of this case, and the petitioner shall be at liberty to place his contention along with all relevant documents before the authority at the time of hearing. Accordingly, the petition is disposed of. According in terms of the order, my lord, the petitioner filed my lord, submitted a comprehensive representation before the authority. And that was hard. And the authority passed an order, impugn order, my lord. Your lordship kindly come at only I am reading, my lord, the observation made by the author, respondent number 3 at page 70.
Yes.
My observation from official records. The LA compensation list 1 Satish Mali, son of unknown, Pakuria, in whose favor LA compensation was declared for RS plot number 835 area 0.185 acre, Bagan, Mouja Khalia, jail number 06, award value rupees 99,284, and it was non-verified. The LA compensation valued rupees 99,284 to check the bearing number such and such was given to Learned Court, Howrah, under section 30 of LA Act 1894. The check was expired. The check was expired and the letter was sent to Treasury Office, Treasury Howrah 2, from the Office of Special Land Acquisition Officer HIT, Howrah, for cancellation of the said check. Vide memo number 5-6 such and such. My observation next, my lord, from the records produced by the petitioner, RSROR Simanto Chakraborty, son of Damodar Chakraborty, recorded owner in full share of RS plot number 835. My plot in question, my lord. Mouja Khalia, jail number 06, PS Bali, classification Bagan, Khotian number 390. Affidavit affirmed before the Executive Magistrate Court, dated 23rd August 2022. Sri Gopal Chakraborty, the petitioner, my lord, the son of late Simanto Chakraborty, village Khalia, post office Chamrail, PS Liloa, district Howrah, is only one legal heir of late Simanto Chakraborty. Thereafter, my lord, my observation from the ROR produced by the BL and LRO Bali, Jagacha, by memo number such and such, my lord, and memo number such and such, one authenticated RSROR, Simanto Chakraborty, son of Damodar Chakraborty, recorded owner in full share of RS plot number 835, Mouja Khalia, jail number 6, PS Bali, classification Bagan, Khotian number 390. My lord, next, my lord, report dated from the inquiry report submitted by H. Chakraborty, assistant LAO, Report dated 13/10/2022, 7th of November 2022, and 14th November 2022. No person named Satish Mali, son of unknown Pakuria, was there in Khali and Pakuria, Moujas, last 30-40 years as per local villagers. Investigation report, my lord. The award has been given to one Mali. Mali has no existence. As per above observation, it is to be concluded that no person named Mali, Satish Mali,
So it is in your favor.
my lord.
The order is in your favor.
No, my lord. Award, my lord. That award was given to the Satish Mali. That award is given to me. Land is about 11 kattas. And alleged award is given to one Satish Mali who has no existence. Mali in the year 2002, probably. 2002, not 4. That award is given to me without acquisition proceedings, without notice to the petitioner. That award is given to me. I always made representation before the authority to give me the possession of my land. I am unwilling to give my land. But authority did not do so.
It has been utilized by the KMDA, I think, the land.
Land is still vacant, my lord, not utilized.
Yes.
The land has been vested well in accordance with law. Thereafter, my lord, the award has been declared, and my lord, the name the award was declared is not traceable. That is, it has been deposited under section number 30. The Act 1 of 18.
What appears.
Land has been vested. Where is the acquisition case number, etc.?
That has been mentioned.
It appears from the, this is an order passed. In respect of this particular
First paragraph,
lot,
page 16.
the awardee, name of the awardee was Satish Mali. It was recorded as Satish Mali. And subsequently it revealed, as it reveals from this order impugned, that the land, this petitioner is the owner of the land, not the Satish Mali, and so existence of Satish Mali could not be detected. But the award money in respect of that particular portion of the land has been sent to the court under section 30. So regarding the process of acquisition, my lord, there is no, but there appears to be a mistake in respect of the name of the award.
No, not only that. The petitioner is an unwilling land loser. He doesn't want to part with his land. Where is the acquisition proceeding made upon notice to the petitioner?
When this.
He should have been given an opportunity of filing an objection.
But allow us.
Where are those documents?
The state should file an affidavit disclosing all the documents.
But may I submit, my lord? But the land cannot be vested under LA Act. Because LA Act, land to be acquired.
Yes.
Under the LA Act. But learned friend is submitting, the land has been vested. This is wrong.
Acquired.
Acquired is another thing, vested is another. Acquired without notice to the petitioners.
How about?
Where are the acquisition documents?
Simanto Chakraborty is the fiduciary interest of the petitioner.
Yes.
Yes.
His name is appearing in RS record of right.
My lord.
Thereafter, perhaps the land has been transferred from Satish Malad. That have to take instruction how much the land.
No, the order says that Satish Mal has nothing to do with the land.
But in his name, the award has been declared.
Then you have found out your mistake and now you have declared it. Please see the last page of the order.
The last page of the Satish is not found. That is why the previous owner is the Simanto Chakraborty, and his legal heirs is not present petitioner.
No, that is the mentioned previous owner.
There is no question of
Mentioned previous owner. What is the mentioning?
Say that it was wrongly given to, the award was in the name of Satish Mali?
My lord.
Inadvertently.
This land was acquired in connection with LA case number 32.
Acquired.
And LA case is there.
Possession was taken on.
First, page 68, my lord. First paragraph.
Page?
Page 68. Impugn order. First paragraph, last page. Case number 32/1, Act 2 of 1986-87.
না না এফিডেভিট ছাড়া কি করা হবে?
করো না তাহলে আগে বলতে পারছে না যাই হোক করো তোমাদের ব্যাপার তুমি করো
Without affidavit, it can't be decided, my lord, when all these anomalies are there. Let the state justifies all these.
The notice upon the petitioner does not rise because he is not the recorded owner. my lord. Notice-
Who is not the record? The petitioner's father is the recorded owner. And you have admitted it.
That we have to take instead of.
You have admitted it, sir, in the order impugned.
There is a land acquisition case where the notice has been served on that. I have to find my evidence. my lord.
So will you come back with a report?
That's why I can find my-
It would be better, my lord, he is challenging the reason order. So let, let affidavit in opposition be filed by the state.
Right.
And we will also disclose certain documents, my lord, we have.
Back with reports, Mr. Talukdar. Why
Also,
affidavit
kindly-
in
kindly
opposition?
After, it's a second round of litigation. After your lordship directed the authority to consider, the authority considered and passed this order. Now several anomalies he is pointing out. My lord, let an affidavit in opposition be filed.
Come back
justifying
with
all this.
reports annexing relevant documents. If that is not sufficient, I'll think about affidavits. Why prolong the matter unnecessarily?
Not prolonging, but the affidavit is necessary.
We can
because in
dispose it
report-
upon
In,
reports.
in report, many things we cannot say.
Why not? It's on
We
affidavit.
cannot deal with the statement of the,
Report is on affidavit.
no, the statements of the petition, we cannot.
The
deal with
petitioner has nothing much to say because it's an admitted fact that it was wrongly given to Shotish Mali earlier. Then it was detected that
The
the
wrongly-
petitioner's father is it is recorded due to inadvertence. That is the language.
Let the
The state cannot improve on that.
With the requiring body, we are those suffer.
It is contended on behalf of the petitioner that his land was taken away by the state respondents and made over to the KMDA without initiating an acquisition proceeding or
Worship, kindly do not record this. Because
it is
this land
submission
has
of the
been,
petitioner.
no, acquisition has been done.
It
but-
is contended on behalf of the petitioner. That is how I am starting.
I'm sorry.
Ki bolam, without and extending an opportunity of hearing to the petitioner. Paragraph, learned counsel for the respondent submits that the land in question was acquired by the state respondents vide LA case number 32/1 within bracket Act Roman 2 of 86/87 as appears from the order impugned dated 7th December 2022. Stop. Learned counsels seek to submit separate reports in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 19th September should be sufficient.
my lord
Appear on behalf of the state respondent. Last
Petitioner?
occasion, I have filed the report on affidavit, my lord.
Petitioner,
Yes,
your
lord.
appeal.
Lord, I have taken exception.
He is filing the exception today, my lord. So in respect of this, my lord, the question arose here, I have to take little instruction from the authorities.
You've not served an advance copy.
Yes, my lord, I called him up, but somehow or other, my learned friend didn't receive the phone.
Exception used by the petitioners to the report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the state respondents seeks to take instructions with regard to the exception. Paragraph, let the matter appear under the same heading on 19th September.
But I'm appearing for the respondent, my lord. Respondent number 3, my lord.
Petitioner, My lordship, I am appearing on behalf of the petitioner. Who is appearing for the petition?
My
You
lordship,
are
I am
appearing?
appearing. My
Yes.
lordship, Kishore Datta is on his way, my lordship. We can start, my lordship, or he's on his way. Sir, my lordship, sir is on his way.
My lord.
Are all the respondents represented?
Yes.
And I'm appearing for respondent number 3, the oil company, my lord.
There are several private
Yes, my
respondents.
lord.
My lord, I'm for the private respondents 5 to 14.
There. Yes.
My lord, this is with
My lord,
regard.
1 and 2 is separate from 3, my lord. That is state and the.
1 and 2, Mr. Dey is appearing.
Oh, I'm sorry, my lord.
Yes.
Lord, this is with regard to, my lord, a property which was let out to, my lord, the Indian Oil Corporation as, my lord, the petrol pump. My lord. Now, thereafter, my lord, there was a claim of thicca tenancy, my lord, and my lord knows, my lord, that so far as, my lord, there are judgments which says, my lord, that the petrol pump doesn't come within the purview of, my lord, the thicca tenancy. This petition, my lord, we have filed, my lord, seeking, my lord, that there should be a declaration that this is not a, my lord, coming within the purview of thicca tenancy and, my lord, an eviction order, my lord, they are, my lord, holding on this property, my lord, till date.
The lease has expired?
Yes, my lord. The lease has expired.
You've received rents?
Yeah,
After that?
my lord, there is a suit pending to that extent, my lord. My lord, I'm being. My lord, I'm late by mistake.
Yes.
Now, first is, my lord, in 1968, my lord, a lease was granted by our predecessors. Now, this was a 45 years lease, my lord, in favor of IOCL. Now, my lord, IOCL, my lord, is running a petrol pump over there. Now, my lord, in the meantime, my lord, the grantor died, then will probated, etc., etc. My lord, many things had happened. Now, my lord, a writ petition was filed earlier before this court, more particularly regarding, my lord, deposit of rent and, my lord, protection from dispossession. With that, my lord, the virus of the Thicca Tenancy Act was also, my lord, challenged. Now, my lord, this writ petition was transferred to LRTT. Then, while this was going on, my lord, on 31st of July 2013, my lord, kindly note the date, my lord, 31st of July 2013, my lord, the lease expires. Now, my lord, we initiate an eviction proceeding against IOCL. Then, my lord, in the eviction proceeding, my lord, an Order 7 Rule 11 application was filed. Nothing has happened over there. Thereafter, my lord, the next date is important, is 6th of December 2020, my lord, IOCL seeks a fresh lease from us. This, your lordship, will come find, my lord, from page 103. Please have a look to, my lord, page 103.
Yes.
Please take note the second paragraph. Indian Oil Corporation is in possession of the land and is running its retail outlet therefrom without any interruption. It appears from our records. As per market information, you are the landlord, present landlord, legal heir of the erstwhile landlord of the premises. Now, through this letter, Indian Oil Corporation Limited intends to express its willingness for a fresh agreement in respect of the said land with fresh terms and conditions. In view of the above, you are requested to convey your willingness, consent in writing in case you are agreeable to offer the land to IOCL with fresh terms and conditions of the lease agreement. Further, please send us your initial offer so that further action for regularization of the agreement with fresh terms and conditions can be taken at the corporation's end as per policy norms of the corporation for procurement of the subject land. Further, you are suggested to provide deeds, title documents, potcha, mutation certificate in support of your claim of ownership so that necessary title search can be carried out as per the policy of the corporation. Now, my lord, two things, my lord, are important or my lord, appears from this letter. Number one is, my lord, so far as our IOCL does not dispute any title of ours. Number one, and number two, my lord, that, my lord, the lease has expired. And, my lord, this is a prayer for fresh lease, not neither a renewal
renewal of course again is a fresh lease, nor a case of extension. Now, my lord, we replied to this letter through our learned advocates, my lord, at page 104. My lord, a lot of things have been said. Kindly take the last paragraph at page 106.
Yes.
Our client has instructed us to inform you that our client is not interested to enter into any fresh arrangement with you to continue in possession of the said premises, hereby call upon you to hand over possession, etc. Now, my lord, we are, my lord, at this juncture before your lordship, my lord, in this factual background. Now, please take, my lord, my prayers. First prayer is a declaration that petrol pump situated at so-and-so did not vest either under the Calcutta Thicker Tenancy Act or under the West Bengal Thicker Tenancy Act. Then a declaration that the respondent number 3 does not have any power authority to exercise option in respect of their land after the expiry of the lease. Then mandamus to forthwith resign, withdraw, cancel that letter which I placed. Then D is directing them to, them means my IOCL, to hand over vacant and khas possession of so-and-so land. Then occupation charges, etc. Yes. Now, my lord, this is the factual background of this case. Now, my lord, how is a writ maintainable? That would be my first thing, number one. And number two, possibly preempting my learned friend, that there might be an objection taken that it should go before the tribunal. I'll address your lordship, my lord, beforehand on both this aspect. Now, so far as whether it should go before the tribunal or not, my lord, the law has been decided by our High Court, which has ultimately, my lord, been settled by the Supreme Court, which is, my lord, Jotadhari's case. Give that judgment. My lord, which is 1986, volume 1, Calcutta High Court notes, page 1.
Yes.
But please take note paragraph 1 of this judgment, which lays down the terms and conditions, my lord, under which, my lord, the lease was granted. Para 1 says, on so-and-so executed an indenture of lease on 9th of November 1954, demising in favor of Burma Shell, such and such, for a period of 20 years. Then, my lord, the terms and conditions, salient features, my lord, has been noted. Then paragraph 2, my lord, finds, my lord, the lease has expired by influx of time on so-and-so. Now, after this, my lord, your lordship may kindly take, my lord, paragraph 65. Or 64 first. Learned counsel for the respondent contended, on the other hand, that the appellants were not Thicker tenant under the Thicker Tenancy Act or the present Act of 1981, and the premises were not held under a Thicker tenancy. The admitted position was that a petrol pump and service station, permanent and pakka structures have been constructed and were still standing on the said premises. The usual, my lord, structures of a petrol pump. Under section 2(5) of the Act, a Thicker tenant was the one who erected any structure on the land under tenancy. The expression any structure had been judicially interpreted to mean a temporary or a kacha structure and not a permanent or a pakka structure. In section 3(8) of the Act, a Thicker tenant has been defined to be a tenant who has erected or acquired any structure on the land under tenancy. It was contended that under the accepted rule of interpretation, when words in an earlier statute has been judicially interpreted and repeated in a later statute, it would be presumed that the legislature intended to give the said words the meaning as judicially interpreted in the earlier statute. Then we're not skipping over paragraph 66 and then 67. Kindly take 67. Learned counsel for the respondent cited so-and-so. Here, a suit for permanent and mandatory injunctions filed by a landlord against Thicker tenant. It was contended by the tenant that under the Calcutta Thicker Tenancy Act, a Thicker tenant was entitled to erect any structure, including a permanent structure. A learned judge, para 60, of this court, construing the scheme of the Calcutta Thicker Tenancy Act 1949, held that the words any structure in section 5 of the Act did not include a permanent structure. Then the last paragraph of this judgment is paragraph 88.
Yes.
The lease in the instant case was for a period of 20 years. Therefore, the company could not claim to be a Thika tenant under the respondent under the Calcutta Thika Tenancy Act at the date of filing of the suit. Further, Section 2(5) of the 1949 Act defines a Thika tenant to be a person who had erected or acquired by purchase or gift any structure on the land under Thika tenancy. The expression structures in the statute has been construed by this court in Manmathonath Mukherjee SUVRA, and it was held that the word structure did not include permanent structure. In the instant case, it is not in dispute that permanent structures were existing on the land and had been erected in the said premises, and that at the commencement of the lease, there was a permanent structure existing in the premises as would appear from the map or plan annexed to the lease. Therefore, my lord, finally, my lord, the court held that the Thika Tenancy Act did not apply. Please take para 100.
Yes.
Which says that the act did not have any application. Therefore, my lord, the Jotadhari, my lord, for the first time considered what is the applicability of the act in respect of petrol pumps. Now, my lord, the Jotadhari, my lord, went to Supreme Court, please, which is no, I'm sorry. Then, my lord, is Lokhimoni's judgment. I'm sorry. In fact, Jotadhari went to Supreme Court. I don't have that. This is reported in, amongst others, AIR 87, Calcutta, page 326. Please take me only one paragraph. Now, this is a full bench judgment of our High Court. Only one paragraph, that is para 56. কোথায় গেল পাতাটা খুঁজে পাচ্ছি না
56, yes.
Just give me a moment, I can't find that page. Printed page number টা বল 94. 94. Yes. We're at the bottom of that page. For the reasons aforesaid, we hold that the impugned act is not protected under Article 31C. We are not required. Please take B. Within the scope and ambit of Section 5 of the impugned act, only lands comprised in Thika tenancies within the meaning of the Calcutta Thika Tenancy Act, comprising a kacha structure and or pakka structure constructed for residential purpose and permission of the controller under the Calcutta Thika Tenancy Act 1949 and khatals held under a lease shall vest, save aforesaid, no other land or structure vest in the impugned act. Therefore, here, Miller, it is clarified that only khatals or kacha structures is to vest. Now, Miller, in the meanwhile, Miller, there were some Miller discussions to the contrary, but Miller, finally, Miller, Supreme Court, Miller, in 2022 restores Lokhimoni's judgment. Miller, I'm told, Miller, subject to correction, that against Lokhimoni, Miller, an appeal was preferred before the Supreme Court by the state, but it was withdrawn. Miller, subject to correction, Miller, I make this submission. Now, the latest one, if your Lordship may kindly have a look to Miller, 2022 SCC online, SC 920. Nimai Chandra Kumar. I'll give you the copy.
Yes.
But please take me only one paragraph of this judgment, that is para 126.
The conclusion.
I'm sorry,
the conclusion.
Conclusions.
Yes.
In summation of what has been discussed herein above, we could broadly say One, the full bench decision of the Calcutta High Court in Lokhimoney is affirmed. The structure as put up by appellant, etc., that is not required, etc., no, that is not required. Therefore, Supreme Court may not finally, in the meantime, there were some discussions to the contrary, but finally, the Supreme Court says that Lokhimoney is affirmed. Or in other words, except Thatal, nothing else vested.
Yes.
Milord, this is the legal situation as of today. Therefore, Milord, in my very humble submission, a petrol pump land, Milord, does not come under, Milord, the Act. And therefore, Milord, I cannot be said to be governed by any of the specified Act, Milord, under the that Act. And therefore, Milord, I need not go before the tribunal for adjudication of my rights, Milord, which I seek to enforce, Milord, over here. Milord, this is my first limb of argument. Now, my second limb of argument is, Milord, in respect of, Milord, these kinds of prayers being entertained by the writ courts. Because here, Milord, the tenant is, or the lessee is an Indian Oil Corporation, Milord, a statutory body, Milord. These were constituted for certain purposes. Now, Milord, the first decision on this aspect is, Milord, was from the Odisha High Court in Dolly Das's case. Milord, this is reported in AIR 1994 Odisha 103. But this is against, Milord, the HPCL, Hindustan Petroleum.
Yes.
But please take me to the second page. In the middle of that page, Milord, there is a sort of a dotted line. And after that, Milord, 4 lines thereafter, on 13th September. There is a sentence starting with on 13th September.
On 30th September, yes.
On 13th September 1989, HPCL intimated Kolingo Automobiles that they are exercising the further right to renew the lease for a period of 20 years commencing from so-and-so in accordance with section so-and-so. The letter has been annexed as Annexure 5 to the writ petition. The present petitioner who has acquired the right of Kolingo Automobiles gave a reply annexed at so-and-so intimating that there has been no execution or registration of any lease in favor of the corporation in accordance with such and such of the agreement subsequent to the expiry of 10 years, which expired on so-and-so, and therefore the question of exercising any further right of renewal under section so-and-so does not arise. The petitioner accordingly requested corporation to hand over premises. The disputed premises in the meanwhile has been mutated, etc. Notwithstanding the request of the petitioner, the corporation having insisted on a further term of renewal, the petitioner has approached this court with the following release. This is very important. To declare that the opposite party number 1 has no right under section so-and-so to claim renewal of the lease, then to quash the letter dated so-and-so, that is the prayer for renewal, and to grant such further orders. Now, in this background, Milord, the Odisha High Court passed this order. Milord, please take, Milord, the next page, para 7.
Yes.
In view of the rival submissions at the bar, the first question that arises for consideration is whether HPCL has any right of further renewal after expiry of the renewed period of 10 years by virtue of section 5(7) of the Act. It is in this context, it must be borne in mind that even though HPCL became the successor in interest of Caltex, the original lessee, while the original lease was still subsisting and the lease expired on so-and-so, but no renewal lease deed has been executed by the lessor. Before delving into inquiry into the first question, it would be appropriate for us to notice the object with which the business in dealing with petroleum was nationalized. Caltex so-and-so, incorporated in so-and-so, and as one of the subsidiaries, Caltex so-and-so was carrying on business of refining crude oil and producing petroleum products in India. Another subsidiary company of Caltex, called Caltex India, which was also a foreign company, was carrying on business of marketing and distributing the petroleum products. Apart from Caltex, two other foreign companies were also dealing with petroleum products in India, namely ESSO and Burma Shell. In order to secure the ownership and control of production of, this part is very important for me, this sentence. In order to secure the ownership and control of production of nation's petroleum resources, and to secure ownership and control of the undertakings carrying on business of distributing and marketing of petroleum products, which would serve the common good, the Parliament enacted 3 such and such acts. And the provisions are in perimeter. We are, however, concerned in the present case with the last act. The main object underlying the act is to acquire the right, title, and interest of the oil company in question, carrying on the business of distributing and marketing petroleum products in India with a view to subserve the common good. After enacting the 3 legislations referred to earlier, the undertakings of the 3 foreign companies stood vested in the central government, and the central government created 2 oil corporations, Hindustan Petroleum and Bharat Petroleum Corporation. The undertakings of the ESSO and Caltex Limited merged into Hindustan Petroleum, and the undertaking of Burma Shell was transferred to Bharat Petroleum. After the enactment of the Act, the validity of sections 5 and 7 was challenged in 2 or 3 high courts, but each of the high courts held the Act to be intra vires. We are not concerned in the present case with the virus of the Act, since Mr. Patnaik for the petition never challenges the same, but it would be appropriate to notice some of the decisions where the virus has been upheld. Now, in this background, Milord, the Odisha High Court, Milord, was considering, Milord, the purpose for which, Milord, the petrol pump or the law relating to petrol pump was framed, so that, Milord, the central government can have control over these resources and the ownership and control of the undertakings. But there are 2 features. One is to control, Milord, the natural resources, and number 2 is to have a control on this undertakings or the corporations, whatever it is. Now, please take, Milord, skip over a few paragraphs. Please take, Milord, paragraph 10.
Yes.
The next question that arises for consideration is whether the Act having authorized only the central government to express its desire, HPCL was entitled to exercise that right. Mr. Patnaik for the petitioner places reliance on a bench decision of this court in Bharat Petroleum versus so-and-so, wherein this court held that the expression, if so desired by the central government, is of great significance, and subsection 2 of section 5 cannot have any application when the central government has not expressed any desire for renewal. No doubt, but pausing here for a moment, but in our case also, Milord, subject to correction, Milord, central government has not expressed any desire, and IOCL is also, Milord, is an undertaking, Milord, which is under the control of the central government. No doubt, the aforesaid decision supports the contention of Mr. Patnaik, the learned counsel for the petitioner, but HPCL, by virtue of legislative enactment and by virtue of the orders of the company law board, having acquired all rights, liabilities, and assets of the former company, and further those rights which were with the central government having vested with HPCL, HPCL could also express its desire for renewal. The power under section 5273 of the Act would thus be exercised by HPCL, and Mr. Patnaik's contention is therefore cannot be accepted. Now, kindly take note the 3rd contention, that is paragraph 12.
Yes.
So far as the last contention of Mr. Patnaik for the petitioner is concerned, we also find sufficient force in the same. The premises in question is the leasehold property of the petitioner, and it has been leased out to the petitioner for being used for industrial and commercial purposes, mainly for automobile shop, room, and service station. The statement and object and reasons of the Acquisition Act indicates that the Act were enacted in implementation of the policy for progressively securing the ownership and control of the products of the nation's petroleum resources, which would subserve the common good. While the central government acquired the business of sale of petroleum of the company under the Acquisition Act, provisions had been made to give a breathing space to the central government or its successor by exercising a right of renewal of the lease for one term so that the affairs could be managed. The object of the Act sought to be achieved being the acquisition of the rights, assets and liabilities of SO, Caltex India and Burma Shell, and that object having been fulfilled, the corporation is not entitled to forcibly take away the leasehold interest of the petitioner. The corporation is running the petrol pump on the leasehold premises of the petitioner by appointing some other person as agent. Therefore, if the petitioner is desirous of continuing the business of sale and of petrol and the terms and conditions are agreed to between the corporation and the petitioner, then there is no justification on the part of the corporation to engage another person as its agent and forcibly occupy the leasehold premises of the petitioner and continue the business. In all fairness, if the petitioner expresses a desire to continue the running of the petrol pump as an agent of the corporation at the premises in question, since the petitioner is the owner of the premises, the corporation should appoint the petitioner as its agent to run the petrol pump. But this is a matter which has to be decided on an agreement between the parties and no mandamus can be issued in that regard. In the aforesaid premises, we issue the following directions. The impugned letter of HPCL under Annexure 5 is quashed, as the corporation does not have any power to exercise option under any further for any further renewal after expiry of the renewed period in 1989. HPCL should deliver vacant possession of the premises in question to the petitioner. The rest is not important for me. I may be permitted not to skip over the rest. So, but this was the judgment of the Odisha High Court, which fell for scrutiny before the Honorable Supreme Court. The Supreme Court's order, where HPCL had gone up to Supreme Court, is reported in 1999, volume 4, SCC, page 450. First judgment. No, I can't. Maybe Lakshmi take this one.
Yes.
Achha.
You take this.
At paragraph 4, the Honorable Supreme Court notes the directives of the Odisha High Court, and then please take para 7.
Yes.
In the absence of the constitutional or statutory rights being involved in writ proceeding, would not lie to enforce contractual obligation even if it is sought to be enforced against the state or to avoid contractual liability arising thereto. In the absence of any statutory right under Article 2, Article 226 cannot be availed to claim any money in respect of breach of contract or tort or otherwise. In the present case, the appellants have sought to exercise their power under Section 7 of the Act, and therefore, though the other consequences may be contractual in nature, the exercise of the right being under a statute, it cannot be said that the respondent could not approach the writ court. Then let's skip over para 8. Please take para 9. We now advert to the contention that the writ remedy is not appropriate in this case, where interpretation of a contract arises in relation to immovable property, and in working such a contract, or relief thereof, or any other fallout thereto may have the effect of giving rise to an action in tort, or for damages, the appropriate remedy would be a civil suit. But if the facts pleaded before the court are of a nature which do not involve any complicated question of fact needing elaborate investigation of the same, the High Court could also exercise its jurisdiction under Article 226 of the Constitution in such matters. There can be no hard and fast rule in such matters when the High Court has chosen to exercise its powers under Article 226 of the Constitution. We cannot say that the discretion exercised in entertaining the writ petition is wrong. Therefore, the Honorable Supreme Court approves this. Now, please take para 12. where the Supreme Court finally modifies the directives, where para 12 instead of reading in its entirety, please take placitum F, E. Between placitum D and E, the sentence starting from the right-hand side of the page, we are of the opinion, last 3 lines, above placitum E. We are of the opinion that ends of justice in this case will be met if we modify the order of the High Court in the following terms. 1. Appellants does not have any power to claim exercise of option for renewal of lease beyond so and so. The appellant seeks and is granted time to hand over possession of the premises to the respondent on or before so and so, subject to filing the undertaking. Rent payable is as per the terms of the lease deed, that is rupees so and so per month, which shall be paid till the date of handing over of vacant possession. If any areas of rent as stated above have not been paid, the same will be paid within a period of so and so. The order made by the High Court to the extent inconsistent with our order shall stand set aside. Therefore, Supreme Court also entertains the point that a writ petition is maintainable, and then modify saying that they do not have a claim. Right of seeking renewal. Which one is this? Yes, just give me one moment. There's a judgment delivered by my lord also on this aspect.
More than one judgments, in fact.
What was in my matter, my lord?
I have not been able to lay my hands on any other.
Which one have you?
This one, delight.
Can I have a copy?
Yeah, একটা copy দিয়ে দাও। এটা খুলে গেছে এটা। ইয়ে করে দাও না। না ওকে দিয়ে দাও। আরে স্টেপল করে এটা দিয়ে দাও। খুলে গেছে, জজকে দেওয়া হয়ে গেছে। এটা স্টেপল করো। Your Lordship was considering at paragraph 9. No, ওটা দেওয়া হয়ে গেছে। এটা
Thank you.
At paragraph 9, my lord has noted Nimai Chandra Kumar I have placed. Then the petroleum HPCL Dolidas I have placed. Shikha Ghosh I have, of course, Shikha Ghosh Shikha Ghosh I have not placed.
I think that's an earlier judgment delivered by this court.
Yes. Then para 10 your Lordship was noting the contentions of the other side. But after all this your Lordship may kindly take paragraph 15. 1-5.
Yes.
It is the admitted position that the deed of lease was executed by and between the predecessor in interest of the petitioner and the predecessor in interest of the respondent on so and so for a period of 10 years, starting with option for renewal of 2 consecutive periods. It is further admitted that the respondents are running a petrol pump in the leasehold property through dealer appointed by them. The petitioner acquired title in respect of the property by virtue of a deed of indenture executed on such and such. Then kindly take paragraph 19.
Yes.
Where at para 18 my lord notes section 6 of the Tika Act. Then para 19. The nature of the structure put up by the tenant in the demise premises has a bearing over the question relating to Tika tenancy. It is right law that on construction of kacha structure on the leasehold land is a sine qua non for constituting Tika tenancy. The expression any structure, including pakka structure, was inserted in the definition of Tika tenancy by the Amendment Act of 2010. Admittedly, the structures raised in the premises in question are pakka structures. Also, the lease ceased to exist from so and so, that is much prior to introduction of section 10A. The proposition of law, as had been discussed by the Honorable Supreme Court in the case of Nimai Chandra Kumar, wherein the Honorable Court has held that the question of land comprising Thika tenancy with erection or acquisition of pakka structure by the Thika tenant came to be provided for only from 1st November 2010 and not before. There was no existing lease as on that date which could have taken the appellant within the frame of Thika tenancy as on 1st of November 2010. Now, here, my lord, having discussed this, my lord, finally, my lord, appropriate orders were passed at paragraph 29. Last page.
Yes.
Paragraph 28, my lord was pleased to, my lord, pass this date. But I am, my lord, praying for the same relief, my lord, in this petition. Because the last letter of the response, I'm sorry, of the IOCL is very important for me. Lease stood expired, accepted. My ownership, my title, not never disputed, and a prayer for a fresh lease. But in my very respectful submission, these judgments will not cover the fee, and this exception, in my humble understanding, is because the central government intended to control this natural resource, number one, and number two, have a control over these undertakings as well. Therefore, in my very respectful submission, once the lease has expired, admittedly, there is no scope of retaining possession, and this is an exception where the writ court can direct handing over of possession. These are my submissions.
Will you continue some other day?
My lord, as my lord pleases.
Because from 12:30, I intended to take up mention.
My lord,
matters.
my lord,
It's already 12.
I am in some personal difficulty tomorrow and day after, any day. My
Friday, Corner?
Uh,
Well, may it be on Friday in that case, subject to the business of the court permitting.
Friday is 1st. Can you come back on 6th?
Oh, 6th, I may not be here. 4, 5. Could it be 7th, in that case?
7th is a holiday. 8th.
8th.
My lord will come on 8th.
But I'll try to lay my hands on any other judgment of your lordship on this aspect. Now that I've got some time.
It's the same issue actually.
Yes.
Her learned counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration on 8th September.
But some precedence may be given on 8th to this matter.
Fairly at the top.
I'm grateful.
Deeply obliged, my lord.
Here for the petitioner, my lord. Here, my lord, under Act 2, 172. 172. 172. You mention matters.
Yes.
Activity of service.
Mr. Day is appearing for the state. Have you served? Where's the service?
For the service.
Service.
Correct. I'm told my affidavit of service has been misplaced. It was served, my lord. It was served, my lord, but affidavit of service was misplaced.
Serve and come back.
My lord.
It's only the state, shouldn't take much time.
My lord.
Since service upon the state, upon the respondents is not complete, comma, let the matter stand over till 19th September.
19th September.
19th.
On 73, I am for the petitioner, my lord. This is my affidavit of service. After mentioning this matter, I went to the serve again, my lord, the notice. Mr. Subhabrato Das appeared for the state respondent. He has stated, Subhabrato Datta, my lord, he is no more in panel, my lord. So, my lord, your lordship, my lord.
Not in the panel.
Panel, my lord. Previously, he was the panel. Brief was allotted for him, my lord. But recently, my lord, he, my lord, the change panel was.
Serve and come back.
Yes, my lord.
Affidavit of service. Paragraph, since there has been a change of learned counsels in the state panel, the petitioner is directed to serve the office of the learned Governor Peter afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 19th September.
Yes. 174. I am for the petition. I have served.
For the state.
My lord, I am appearing for the DFCCI lordship.
Yes.
Item number 18 to item number 22, lordship.
Hey,
This is 174. 174. Item number 174.
My lord, item number 15, then item number 174.
Have you checked the list, madam?
Yes, madam.
What is there? What is stated in the list?
Mute করে দাও না।
Matter has been mentioned without giving any notice to us.
You are appearing for?
Yes, I have served, my lord. I have served.
So you
I have served, my lord. I have served, my lord. My lord, kindly see, my lord. Kindly see your.
Mention upon notice.
Yeah? No, my lord.
Then please mention upon notice so that matters.
My lord, I have served the state respondent, my lord. Yes, my lord. The region order stated, my lord. Region order on that plea, my lord, they have taken instruction, my lord. My lord, kindly see the region order, my lord. After receiving the same notice, my lord, they are not present before the authority, my lord, for as per your lordship direction, my lord. Your lordship directed, my lord, to consider my representation in presence of all the parties, my lord. They have authority, my lord, sent a notice all the parties, my lord. The rail was not present, my lord. So, my lord, region order was passed. Without, my lord, the rail authority, they have not. Kindly see the region order, my lord. Kindly see the region order, my lord. Page 44, my lord. Page 44, my lord, 30th December 2022, my lord, the order dated, second paragraph, the petition submitted that, my lord, notice sent, served to them, attending hearing in both occasions, but they are absent. Here, my lord, I have not served, my lord. The hearing authority sent two notice, my lord, but both occasions they have not present.
Yes, madam, the order was passed and it was found that there is no record with regard to the acquisition of the picture that you logically come to.
Yes, but the rail was acquired, my lord. Rail was absent at the time of hearing. So, my lord, the hearing authority stated, my lord. They have taken instruction, my lord. They have taken instruction whether they are acquired or not, my lord. If they are not acquired, I will obtain my land, my lord.
Take instructions and come
Yes.
back. You'll come back with a report in the form of an affidavit?
Yes, ma'am.
Will you come back with a report in the form of an affidavit?
Yes, madam.
Yes? State also needs to find a report?
My lord, we have an instruction, my lord, already,
You want to
but
put it
not
on
in the form of report.
You want to bring it on record or you'll come back with a report?
Yes, your lordship, as per your lordship, sir.
Affidavit of service. Learned counsels for the state respondents and the railway authorities seek to submit reports in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 20th September.
Yes.
20. Please serve advance copies.
Yes, ma'am. আমি কি করব 175 I am for the petitioner, my lord. Sir, I am late by my.
Yes.
But I am appearing for the state. If your lordship kindly take the matter, my lord, day after tomorrow, then it will be better because, my lord, I have already contacted with the, my lord, the BLRO because I have got a report from the highway division. They said, my lord, they have already directed as per the petitioner's representation. My lord,
They've initiated.
from the SDO, my lord, the highway authority got the, my lord, representation of the petitioner. My lord, they have already, my lord, took a spot inspection. And, my lord, though the petitioner was not present, but the other shop owners, they are present. They said they are the recorded owner. That's why, my lord, the highway division directed the BLRO to conduct a, my lord, the demarcate the property.
to that extent, my lord, I have got the report, my lord. Your lordship kindly see the report. And my lord.
So for spot
All the private respondents are served.
Yes, affidavit of service, here.
So far spot inspection is concerned, it was held on 6th of June 2023 and I was present over. For my instruction, I have stated on the petition.
So
also,
what
my lord.
happened thereafter?
Nothing has been done, nothing, no communication. Page 10, paragraph 9, I have stated that I was present during this joint inspection.
It is under the Highways Act.
My lord.
Yes, do you have instructions in this regard?
On that respect, I have got the issue. I have said just no.
Because the petitioners allege unauthorized construction on PWD road.
Well, this is the instruction I have got.
Have you dealt with the representation?
Yes, sir.
So the demarcation is pending.
Yes, my lord. So, my lord, my lord, pray, my lord, if your lordship kindly give another date so that probably BLR will come to give his instruction or anything else. So if your lordship kindly place the matter 2 weeks hence, my lord, then we can see that.
Don't you think
যদি বলো যে আজকেই করে নেবে তাহলে করো। Then representation may be considered.
representation has been considered
Yes,
and it's waiting for demarcation?
Yes.
So let the BLLRO demarcate within 1 month from date. And then within 2 months thereafter, the proceeding will be completed.
Yes.
Yes. Why waste further time?
And may I get a copy of that report?
One copy is there only for your lordship. I think Mala, there is no other.
Xerox and give it for your lordship's record.
There are 3 copies of the same statement.
They have any probably at.
Then give
Your
one
lordship, can you give me?
one to the court, keep one for your.
Yes, my lord. I saw. আরে ওরা এমন ভাবে করেছে খুলতে পারছি না।
Please, you can take out 2 copies. There are 3 copies. একটা থাকবে আমাদের কাছে। Affidavit of service. Affidavit of service, paragraph. None appears for the private respondents despite service.
দরকার দেওয়ার কি দরকার?
Paragraph instructions submitted on behalf of the state respondents is taken on record. ওটা নিয়ে নিন কিন্তু, হ্যাঁ? Paragraph. The petitioners allege unauthorized construction raised by the private respondents by encroaching upon a portion of the PWD road adjoining their property, thereby obstructing their egress and ingress. Stop. The petitioner submitted a representation before the concerned authority on 18th May.
Yes.
On 18th May 2023. And pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the it is submitted by learned counsel for the state respondents, comma, on instructions, comma, that pursuant to the representation submitted by the petitioners, comma, a joint
Page 42.
spot inquiry was conducted by the authorities and the shop owners having their respective shop rooms in front of the boundary wall of the premises of the petitioners claimed to be recorded owners of the land in question. Stop. The Block Land and Land Reforms Officer has been requested to demarcate the extent of the PWD land and submit a report along with a sketch map before the concerned authority. Stop. The demarcation is still pending. Paragraph. In view of the above, comma, this court is inclined to hold that the Block Land and Land Reforms Officer be directed to demarcate the
Respondent number 6.
plot in dispute. I'll pass, this is just the observation. Please let me continue. Ki bolam? In dispute and submit a report to that effect before the assistant engineer who, comma, in the event of encroachment of PWD land, comma, shall initiate appropriate proceedings in accordance with law. Paragraph. The writ petition is accordingly disposed of, directing the sixth respondent to demarcate the plot in dispute and submit a report to that effect before the
Assistant Engineer Krishnanagar Highway Subdivision.
Yes, but respondent number?
But
He's not a party, but Malat,
executive engineer
Malat,
is
in the
Not with the party.
Malat,
It should be the
executive engineer is the party.
no Malat.
It should be the assistant.
But kindly grant me leave, Malat.
I'll add, please add him as a part. Before the
ওরাই বলেছে আমি জানি না এই দাও।
ওই এটা
28th respondent. Before the 28th respondent, within 1 month from date, stop, upon receipt of such report, comma, if it is found that the PWD land or any portion thereof is encroached upon by the private respondents, comma, the 28th respondent shall initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within 2 months from the date of receipt of the report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, comma, in accordance with law. Disposed of which line? Ekdom shuruতে করুন, on prayer of the petitioners, comma, liberty is granted to implead the assistant engineer, comma, Nodia Highway Division 1.
Yes, Malat.
Nodia Highway Division 1.
Yes, Malat, it is Malat. Yes, Malat.
Nodia Highway Division
One.
number 1, comma, Public Works Directorate within bracket roads, comma, Government of West Bengal, as respondent number 28 in the writ petition. Stop, the cause title of the writ petition be amended accordingly. Please incorporate the necessary corrections.
Malat, the instruction be kept.
Taken.
And within 1 month, the demarcation will be done.
1 month and another 2 months.
I'm
Because evidence will be required. ঠিক বলেছি একদম শুরুতে বলেছি না? হ্যাঁ, হ্যাঁ।
16 my lord, I am for the petitioner. Here the petitioner purchased a property in 1983.
Respondents, Mr. Dev?
Lordship. Now, my lord, and land acquisition case was initiated in 1998-99. Award was issued in 2002 in respect of a person who is not the owner. I am the owner. So I made a representation. And my lord,
Submitted for HIDCO.
well, kindly come to page 63. An order has been passed pursuant to the order direction given
Serve
by
the HIDCO.
Lordship. Right. Affidavit of
Where is your affidavit of service?
highlights. But I'm giving to it. Hitco service commission. Well, everything, everybody has been served, my lord. The only thing, lordship, that has been served.
Yes.
But kindly come to page 63. And the order has been passed that the amount has been deposited before the learned court below. As per section 31. Now I have to approach the court for my lord disbursement of the amount. There is no difficulty. A 73 years old lady, my lord, is fighting for the money of which he is lawfully entitled. But my lord, only thing is required is the details of the my lord, deposition of the amount, the memo number, the date, the exact amount. But that has not been provided. That has not been mentioned even in the my lord, this order. Because otherwise I cannot trace the record.
Have you asked for it before the authority?
But they are bound. When they are passing a recent order, they should specify all the details in the
Since it
recent
is
order.
not specified, did you file an RTI or something before the authority?
At the time of hearing, it was pointed out.
Before approaching this court?
At the time of hearing, it was pointed out.
Page
Page 63, your lordship will see.
63,
Number
yes.
is there, everything is there. Why my planet?
Well, not number is there. By a specific memo number, they have.
Was deputed before the LHR on court number 11 February 2020.
The
For
specific
identification,
memo number is
31
required by which they have deposited the amount before the my lord court below.
9899. Nothing except this, well, nothing is required. He can file an application before the LHR, my lord.
But I can file an application. That right I have.
He is the owner
Under
of
section
that.
33, that right I have. But I need the my lord specific memo number by which they have forwarded the amount. Otherwise, I cannot trace the record.
Why not? You can file an application with reference of the LKS number.
Lordship, that my lord I can. My lord,
Yes, then.
kindly give me the liberty to my lord make this application and let them provide it within my lord specific time.
Yes, my lord.
And I have already made an application, my lord. That is at page 67.
That, my lord, you will get the money.
What are the impugned orders that you have assailed? 11 July, 28 July, 4th August, what are these orders?
My lord, that is the
My-
final order.
That is the final order, my lord. Page 61. That is the continuous order passed in the my lord pursuant to a direction given by your lordship. Page 61 to 63.
61 starts, my lord, 63 final order.
63.
4th August 2020.
That is an order of reference.
Lordship.
Yes.
This is not reference, my lord. 31, that is, my lord, we deposit the money according to 31
yes.
of the act, my lord.
I am not disputing that, my lord. I am not also
My lord,
disputing
you will
that.
get the money
Only thing is
by
required
that, my lord.
is the forwarding details, my lord, so that I can trace the record and proceed the my lord court below, so that I can get the amount.
বললেই টাকা পাবে, এই reference number.
পাচ্ছি না, record খুঁজে পাচ্ছি না।
করেছিলাম, আমরা রেকর্ড পাচ্ছি না, এখানে আমরা
That is the difficulty. Why I am before your lordship, my lord.
Record পাবে না, হয় নাকি?
পাচ্ছে না।
তুমি করে দেখো না।
করে দেখেছি স্যার।
হ্যাঁ। নাহলে আমাকে বলো, আমি বলে দেবো।
ভেরি ওয়েল, খুব ভালো কথা।
ব্যাপারটা হয় নাকি তাই? পাবে না 11 দিন?
আমি অ্যাপ্লিকেশন করে
I am
জানিয়েছি ওদের।
praying for a simple direction upon the my lord authority to provide me the reference details, nothing more, my lord,
Then we will proceed.
so that we can proceed.
My lord, that is the reference.
That is what even I
That
think
is
the
the
LKS should be
reference,
the
my lord. I
reference.
can't understand why my learned friend.
Because I have tried before the learned court below to get the records, but I did not get it. That is why I am before your
My lord,
lordship.
that is
Only the
fine.
memo number.
To get the records, you need to file an application in
For
terms
the
of the
LKS.
LKS.
Particular memo number বলে দাও না একটা।
I just need the particular memo number by which they have deposited the amount.
How is that relevant?
Because
Because a separate
by
case has been
following this
registered.
lordship,
A miscase has been registered.
this case
isn't
will be
it?
registered as per section 33, my lord,
Yes.
lordship.
So you have to file an application under section 33.
That I have to file, that I have to file to get them.
You have to you have to refer to this LA case number.
Lordship.
You don't need the memo by which they have filed, they have sent it.
But my instruction is, my lord, they are not getting the details of the record, my lord. Without getting the memo number, the court will not find out the details of the record by which the entire document has been deposited by the learned court below. That is my instruction, and that is why I am before your lordship.
My lord, I can give him memo number, my lord, within 15 days and
That will serve my purpose.
My lord, directing to file.
So I have to record your submission in
Yes, ma'am.
Yes.
Only memo number.
Only
nothing
memo
else.
number, only memo.
That will serve my purpose, ma'am.
Affidavit of service. The petitioner seeks to approach the land acquisition court, land acquisition judge under section 33, isn't it? 33 of the Land Acquisition Act, in terms of the order passed by the district magistrate and collector, South 24 Parganas, on 4th August 2022, and seeks a direction upon the state respondents to provide the memo number by which the matter has been by which the compensation amount has been deposited before the said court. Paragraph.
My lord, I have that.
You have the memo number?
Yes, ma'am.
Then your lordship can dispose of this matter.
I have handed over the same.
Please give the number. The memo number being.
একটু my lord ও দিদি শিখা দি একটু my lord memo number
স্যার একটা কপি দেবেন, আমি জেরক্স করে নিয়ে আবার আপনাকে দিয়ে দিচ্ছি।
L stop A slash হ্যাঁ না 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 ওখানে না লার্নেড কাউন্সিল কি বললাম ওখানে স্টপ দিয়ে দিন paragraph. Learned counsel for the state respondents, comma, in his usual fairness, comma, provides the memo number being L stop A slash 2054 slash 1 within bracket 3 dated 11th February 2022 has provided volume. To learned counsel for the petitioner in court this day. Paragraph in court this day. Paragraph in view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Paragraph urgency of the
This is your features.
has provided in court this day.
এটা কিন্তু ভালো
As I
Once.
None appears, no accommodation is sought, dismiss for default, full order. Same order. Same order.
Like we told you.
My lord, in this matter, Mr. Motion is appearing from the contemner.
Well,
The order has been complied with.
I am
my lord.
appearing on behalf of the
With
petitioner.
Compliance report. my lord.
Complied? Mr. Khan?
Actually, it is not a complaint at all. So kindly see the
Have
order.
you received copy of the compliance report?
Yes, just today I have received.
So you want to go through it and come back?
Yes. I've gone through the matter, but kindly see the order at first.
Madam,
Page number 92. Page number 92.
The authority was directed to revisit the issue.
Yeah, my lord, contract carriage, state carriage permit. Application was made in respect of my lord Mexicab for state carriage permit on a particular route. My lord, in the fourth round writ petition, after fourth round writ petition, this point had been decided by this honorable court. And now I'll show the page number 97, the second paragraph. Having heard the parties and considering the material placed, this code is of the considered view that is setting aside the note of the notification dated 20th February 2013, which was issued in possession of all previous order direction pertaining to Mexicab, small passenger vehicle breakers impliedly, and or by implication, the previous order dated 5th of April 2003 also stood superseded. Such order dated 5th of April 2003, therefore, could not be resurrected by the RT Nodiai at present to reject the case of the petitioner in WP numbers without obtaining judicial clearance. In the backdrop of the above discussion, the impugned resolution dated 11th of August 2013 stands set aside. The RT Nodia is directed to revisit the issue at its next available board meeting in terms of the order dated 2nd of July 2013 and in the light of pages 50, 58 and 67 of WP1. Page number 50, 58, 67, all of annexed my lord, several permits have been issued as a state carriage in respect of authority in Mexicab on the sales level. So, and also, my lord, in terms of this order dated 2nd of July 2013. On 2nd July 13, my lord, that order I be annexed, page number 85. 1st July 13. This order was passed by Justice Bhanga Datta, he was about then. A notification was issued 20th February 2013 that the legality and validity of this notification was challenged in this writ petition. But this notification was issued, page number 85, that notification was quoted. Also, I have annexed, my lord, this notification, page number 83, also.
In the contempt application?
Yes, in the contempt petition, page number 83. On a notification was issued adopting a government policy for grant of small state carriage vehicles, that is Mexicab, small passenger vehicles, pickup, etc. on certain directions guideline. 1, 2, right. That is the total route length of any such route shall not exceed 30 kilometers.
The routes shall be within the jurisdiction of the permit issuing agent authority. And also such routes shall not fall within the jurisdiction of Kolkata city and suburban areas. Such routes shall be traversed along the national highway except crossing at recognized points. Such space-based permits may be on existing bus routes. But this is a condition. Well, why this was challenge? But this notification was issued under section 67. Because section 67 only fixing the PR chart, nothing else. So in the wrong, not the wrong section, this notice was issued for this reason. It was challenged. And page number 85. The last paragraph, my lord, this notification was quoted. Entire notification was quoted in this order. And page number 88. On second paragraph, I will reading that. Since section 67 of the Act provides that notification could be issued by the state government for the purpose of issuing direction to the state transport authority, West Bengal and the regional transport authorities regarding fixing of fare and rates for space carriages, contract carriages, and goods carriages, and notification does not relate to fixing of fares and freight. Same without doubt has been issued referring to section that which the notification cannot be suspended.
Will you come back with an exception, Mr. Khan?
Really,
Yes? Yes.
yeah, that is required because they are the stage carriage. My vehicle is stage carriage, but
Yes.
matter was dealt with by the authority as a contract carriage.
My lord, the hearing has been given, my lord. Hearing has been, kindly see the
See the order.
paragraph,
Kindly see the order.
order dated at contempt application 104, my lord, 105.
But this order was passed.
RTA Nodia is directed to see the issue of the writ of the next available board meeting in terms of the order dated 2nd July 2013 and in the light of pages 50, 58 and 87 of the WPA is accordingly allowed. My lord, kindly see the report page now in the report page 5, my lord. At the top, my lord. The RTA Nodia subsequently by letter dated 10th August requested the petitioner to appear before the RTA board on 16 for consideration for his application for contact carriage permit, maxi cab dated 7/2/2020. Then, my lord, on paragraph 8, my lord, on 16/8/2023, the RTA Nodia, after considering the petitioner application for contact carriage permit dated for considering the relevant issue involved the issue for consideration of such application for grant of contact carriage permit on route applied for, and after due consideration of submission made by the petitioner authorized representation took a decision on the date itself and noted down in the form of resolution dated, he thereby rejected the petitioner pair for following ground. As the route contain 80% bus route and Kollani station is congested as per report of the superintendent of police wide memo number 298 stroke. Yes, my lord. The application for the route is rejected, my lord. Contact carriage permit carrying passenger for hire and revert from one point to another point without via point as per section 2 and subsection 7B of the Motor Vehicles Act. However, he may reapply contact carriage permit for a specified area, namely Nodia, Murshidabad district as per section 74 of the subsection 1 of the Motor Vehicles Act, and reapply contact carriage permit for any institute of any agency with their contact later. The decision of RTA Nodia at the paragraph 10, my lord, has duly been communicated to the authorized representation of the petition.
The order was for revisiting the issue.
Yes, ma'am.
Stage carriage. I applied the stage carriage. The In the fourth occasion,
Mr.
application
Khan,
is a stage carriage,
you are aggrieved by the order. It's a separate cause of action, cannot be dealt with in a content.
The order,
application.
stage carriage, director authority, this stage carriage. I applied the stage carriage and I mean, annexed page number 86 in the order sheet, my lord. The page number 50, 58, all are stage carriages. I also applied stage carriage. Maxi cap as per government notification as the stage carriage. Maxi cap is a stage carriage, not the contract carriage. Because this order was passed 12 February 2020. It is, I have applied stage carriage and this honorable court was directed to consider stage carriage. Can you see the order of the initial stage, my lord? Page number 100. Under challenge that the regional transport authority in Modhya rejected the application of the petitioner for a maxi stage carriage. Initially, my application, I applied stage carriage, rejected after that was challenge. I have never applied. But after the order of the court.
And the authority has dealt with contract carriage.
Contract carriage. Why contract carriage? Because my client was called. When called? On 7th February 2020. This order was 12. I have already communicated that one application has lost. Our initial application, because only old application is lost. You can please directed my client to submit to one application. So that was supplied by the authority. That is the contract carriage. Overlooking the pipeline. He has signed without any fees. If any application, because the further application is not required at all. The order was 12. Consider that. After that, that did not within this somewhere.
Will you come back with an exception to this? Will you come back with an exception to this affidavit of compliance? Please come back, I'll deal with it. Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph copy of the affidavit is made over to learned counsel for the applicant petitioner in court this day. Paragraph, learned counsel for the petitioner seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on
1 month time, because my client has to go to Hello for medical treatment.
1 month time. 29th September. Yes.
I'm for the petitioner. This is appearing for the first time.
Will you serve and come back?
Yes.
13th September.
Page 19, the impugned order, my
Please
lord.
serve and come back and consider. 13th September, returnable date.
One order is
13th.
one order is required for
I am passing an order. Yes. Amlan. Service. Fresh na, sir.
my lord, returnable, my lord.
Yes.
Returnable.
Returnable 13th September. Yes, 181.
My lord, I'm appearing for respondent number 8 led by Mr. Wasim Ahmed. My lord, he is unwell. I'm praying for not today.
Respondent number?
8.
Well, is this matter appearing?
There is no 8th respondent in this matter.
HDB Financials.
5.
5. Whereas, my lord, the contention of the petitioners is concerned, my lord. This is relates to, my lord, Mr. Debra's client. Because
You have implemented the private respondent. So
he is there.
Fault in making payment to the bank. There are the bank.
Your lordship kindly see the last order.
Let him come back.
Your lordship kindly see the order. Your lordship kindly see my lord's order. He has to place the report. Mr. Devrai's client has to place the report. The vehicle has been, yes, not yet. This is 1 or 2 months back.
Not in not
It
in
has to be the form of an affidavit.
Fine.
was a direction.
Extend the time so that
It was extended on the earlier occasion, Mr. Devroy. Please.
Twice, my lord. It was twice extended.
Learned counsel for
I
the
called my lord.
Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as called for. Paragraph, learned counsel for the 5th respondent also seeks accommodation. Paragraph, let the matter appear under the same heading on 19th September.
My lord, kindly
Serve an advance copy, Mr. Devan.
so that my lord, I can in the meantime, my lord, so that I can use the my lord,
Paragraph, report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioner.
so that I can my lord, use the exception.
Grateful.
Upon service of advance copy to the petitioner. Yes.
Lordship, on the last occasion, that is on 24th of July 2023, I, on behalf of the petitioner, filed a supplementary affidavit, which was served in compliance with the order 15th of May 2022. My humble submission, all my humility was that the battery manufacturer.
Take a microphone, please.
My lord, in this matter, Mr. Opposition is I am praying for not today, my lord. Please engage before Honorable Justice Shobhushachi Bhattacharya.
My lord,
Come back some other day.
my can is there, my lord.
The state is not there. Have you received a copy of the can, the application?
Yes, Lordship.
You have an objection to it?
Yes, actually, that's why we just filed the supplementary affidavit.
Can.
Yes, we just filed. Yes, already filed.
You are objecting to the application.
Yes, in the supplementary affidavit, we just filed our objection, but not separately.
Supplementary.
No,
affidavit
not.
Cannot be an objection.
No, but separately, we didn't file any objection. We do not want to file any objection separately.
Objection to the can.
Yes.
Then I'll hear it out on the next day.
Okay.
Since the state is not there.
Okay, Lordship. Okay.
Paragraph
Grateful,
on
Lordship.
prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th September. 20.
Okay. Grateful, Lordship.
28 September. That was September.
But one indulgence, Lordship, we are not filing in a separate objection. That's it.
Very good.
Okay. Grateful,
Make
Lordship.
your oral objection.
Yes. Grateful.
I was addressing on the last occasion.
In this matter, I have made an application for addition of party.
Yes.
Last occasion, I made my submission.
Now, the
You are objecting to the application.
yes, because my lord, according to me, they are neither necessary party nor proper party. Because your lordship kindly see page 4 of their application, paragraph 2.
Have you used an affidavit against this application?
Yes. And they have used the reply also. No.
Yes,
Page 4, paragraph 2.
Yes.
Your petitioner state that your petitioners are the intending operators. They are not the operators. They are intent to operate because the fact of the backdrop of this case is these persons have been granted permit in route number 30C by 2. Sorry, 30C and 30C by 1.
The petitioners.
The applicants, they have been granted permit. That grant is under challenge before this honorable court. My Lord Justice Arindam Sinha initially set aside the grant. Against that, these operators, along with the state respondents, referred to appeals. Appeal was heard and disposed of. Now, my Lord, in the appeal, the Honorable Division Bench, Honorable Justice Dipankar Datta and Honorable Justice Pradeep Prakash Banerjee give two different judgments, but concurring decisions. If you lordship so pleases, I can place that two decisions, that the two decisions will make the things very clear, very implicit. Your lordship can take my writ petition. The two decisions are there. The decision of the division bench starts from page 56. Your lordship kindly come to the operative portion of the judgment. Yes, page 85, paragraph 38.
Yes.
Since therefore both the appeals fail on all points urged, we dismiss the appeals and uphold the quashing of the impugned rescind order dated 22nd January 2016. Its correction by way of a corrigendum dated 4th March 2016 and the notification dated 17 June 2016 published in the official gazette on June 30, 2016 and direct the appellant number 1 in MAT number 1620 of 2017 being the state of West Bengal through its appropriate officer, preferably the Principal Secretary, Department of Transport. And if there is no Principal Secretary, then the Secretary, Transport, the Department of Transport, consider and dispose of the representation made by the appellant in MAT number 1443 of 2017 as exhibited as annexure P3 to the WP number 14545 of 2015 after due inquiry has already directed by the order dated 31st July 2015 passed in the said petition without giving any opportunity of being heard to any person, but after satisfaction of the condition mentioned in section 71(3)(a), read with section 67(3) of the said Act 1988 in the light of the notification dated 2nd August 2004, published in the official gazette part 1, dated 6th August 2004, in strict compliance therewith and in compliance with the judgment in the case of Sujata Ganguly as expeditiously as possible, but positively within a period of 3 months from the date of communication of this order and give effect thereto. Pausing here for a moment. Now, these applicants, along with others, they made a public interest litigation before this Honorable Court, before the division bench of Honorable Chief Justice Dr. Manjula Chellur and Honorable Justice Joyamallo Bagchi.
সামনে দাঁড়িয়ে কথা বলছেন।
Now, that is the public interest litigation 145/45 of 2015. In that public interest litigation, the prayer was that in the route 30C and 30C/1, number of passengers are more, required number of vehicles are less. So the authority may be considered, may be directed to consider our representation for giving more. And these persons who are now intending operators describe themselves, move this public interest litigation as the passenger. Now, that in public interest litigation, nobody pointed out that they are the operators, but even then, the order has been passed for consideration of that. After considering the same, the authority, while considering, asked the learned advocate for the petitioner to appear and issued an order on 22nd January 2016 that the fleet strength is enhanced. That enhancement of fleet strength was under challenge before this Honorable Court, and that has been set aside by the Honorable Single Judge. Then it has come before the appeal. The appeal court was also passed this order. And then the appeal court was pleased to direct. This is the most important part. Your Lordship kindly come to. It is needless to mention that no effect can be given to any permit for the stage carriage on the said route issued after increase of the fleet strength over and above those existing under notification of 2nd August 2004, published on 6th August 2004. This will, however, not prevent the appellants in MAT number 1443 of 2017, Mr. Nundi's client, and the added parties to apply afresh for permits if the fleet strength is increased after completion of the exercise mentioned above. These orders shall also not prevent the appellants in MAT number 1443 of 2017 from seeking variation of the Lordship market, variation, not anything else, variation of the routes to ensure that they do not pass through Central Business District of Kolkata, and if any such representation is made, we are sure that the concerned respondent authorities will consider the same in accordance with law and pass necessary orders as expeditiously as possible. Now, This is the order passed by my Lord Justice Pratik Prakash Banerjee. And my Lord Justice Dipankar Datta was pleased to deliver a separate decision. And in that decision, His Lordship has clarified this situation more precisely. Your Lordship kindly come to page 89.
Yes.
My Lord, last 4 lines of in paragraph 4, the sentence begin in view thereof. Has your Lordship got it? Page 89, the sentence begin in view, just 4 lines above paragraph 5.
In view thereof.
In view thereof, the orders dated 22nd January 2016 and March 4, 2016, together with the notification dated June 17, 2016, since published in the Gazette dated 30th June 2016, have been rightly proposed to be quashed, with which I wholeheartedly agree. Then, as by way of clarification, it is observed that while complying the order of the coordinate bench dated 31st July 2015, passed in WP number 145/45W of 2015, the competent authority may explore the possibility of granting permit in favor of the appellant in MAT number 1443 of 2017 and other applicants for permit similarly placed for plying stage carriages between Hathiara and Satragachi by aligning the route in such a manner that the stage carriages, if at all the permits are issued, do not pass through CBD of Kolkata or Howrah, which would be in consonance with the terms of such and such. So, my lord, route was Hathiara to Satragachi. Initial route was it should pass through Central Business District. Now the restriction have been imposed in 2004. Whatever is there, no further grant. The grant has been made on that score. The grant was dismissed or rejected, set aside. Now the division bench said very well. They can continue with the plying because they have the vehicle. Between Hathiara and Satragachi, you modify the route alignment. That means head and tail will remain. While taking the decision in favor, even if I accept in favor of Mr. Nondi's client, they completely ignored that. They said it is a shelter of the High Court of the division bench. As per the judgment of the division bench, we are making this decision. They have completely formulated a new route, which is neither here nor there. That's the main subject matter in the issue. I am not addressing before Lordship that. Now, my lord, on this score, the decision has been taken. Whether that decision is legal or illegal, that will be decided by your Lordship while deciding the writ petition. Now, the question of addition of party. Now, they have these applicants on the basis of that, a decision, good, bad, indifferent, a decision has been taken by the RTA inviting application. Only inviting application. Nothing more, nothing else. The application invited, they made the application. Had it been a case that the application has been considered and decision has been taken by the authority for issuing offer letter to this person for placing their vehicle, thing could have been different. Their right accrued. But here, this entire thing is premature. No decision has been taken. As you'll also kindly appreciate one thing. Suppose in a tender or in a notification for employment or in an application for permit, several applicants made the application in terms of the advertisement. Permit will be granted to the intending operators, etc., etc., etc. Several, this has been given. And here, the notification is preference will be given to them. It's not that they will be granted permit. Preference will be given, no doubt. Preference can be given. Preference can be given to state transport undertaking. Preference can be given to SC, ST, OBC. Preference can be given to economically weaker section. Preference can be given anybody if the government like. That means that does not indicate that they have accrued the right. Now, these persons, only notification made, preference will be given. These persons who have the permit in the route number 30 and 30 C by 1, which has been set cancelled due as per the order of the Honorable High Court. Preference will be given. And these persons made the application. And the your Lordship kindly see, now these applications were invited in February 10, 2020, the 2023. That is at page 50A.
Page
50A, 50A. 58 now, 50A. Of the application for addition of.
Yes.
No. আমাদের রিট পিটিশনে নেই।
Oh, of the application.
Application.
Yes.
Now your lordship kindly see. The notification says, paragraph 3. Whereas consequent upon the verdict in MAT number 1443 of 2017, Shatarup Bishwas and others versus Abhijit Ghosh and others, to fill up the vacancies in route number 30C/2, giving special preference to the annual 20 permit holders as opined by the Honorable Calcutta High Court. May I put this question to myself? Where is that opinion? I have placed before Lordship the entire judgment. No such opinion has been found by the High Court. High Court says that these persons can be accommodated if these persons made the application for modifying their route. Not a new route formulated. They can be accommodated in a new route. There is no problem. There is no dispute. But not under the blessings of the High Court. High Court did not pass any such order. Your Lordship kindly see. And your Lordship kindly see, what is the High Court's direction, page 90 of the writ petition? Exactly specific, there is no ambiguity in that. What is that? First of all, there are two directions. The authority in their resolution never indicated that whether they have carried out this direction or not. Your Lordship kindly come to page 89 first. Paragraph 5, as and by way of clarification, it is observed that while complying with the order of the coordinate bench dated 31st July 2015, passed in WP number 145/45/2015, the competent authority may explore the possibility of granting permit in favor of the appellants in MAT number 1443 of 2017 and other applicants for permit similarly placed for plying stage carriage between Hathiara and Satrakachi. Route is fixed, not any other route. By aligning the route in such a manner that the stage carriage, if at all permits are issued, do not pass this. Absolutely specific order. There is no ambiguity in that. If they move the Supreme Court, set aside the order, thing could have been different.
But
No.
please come to page 86
Page 86 of my writ petition.
of the writ petition, yes.
Yes, your Lordship kindly see.
This will, however, not prevent the appellants and the added parties to apply afresh for permits if the fleet strength is increased.
That is route number 30C and 30C/1.
Yes.
That has been quashed. Now the next portion, your Lordship kindly see. And the page 85, your Lordship kindly see, page 85, last portion.
Even after quashing, this liberty was there.
No, what is the liberty? Your Lordship kindly see, what is the liberty? Liberty is appellant from seeking variation of their route. The same liberty, variation.
No, even to apply afresh.
No. Variation. For variation, they have to apply. Because variation section is this 80 subsection 3.
There is an also, shall also not prevent.
Yes, these orders shall also not prevent the appellants in MAT number 1443 from seeking variation of their routes.
But prior to that, they can apply for fresh permits also.
These will have not prevent the appellant and the added parties to apply afresh for permit if the fleet strength is increased. That is 30C and 30C/1. Not anything else.
Same route. The same route.
No, this is not the same route. It's a different route. 30C and 30C/1.
They are subject matter of the appeal.
That is the subject matter of the appeal.
Yes.
30C and 30C/1 is a supplementary appeal. Here a new route has been indicated, 30C/2. That route, only Hathiara is there. Other portion is absolutely changed. And it is up to SDF. Not up to Satragachi. Your Lordship kindly see that the route, the decision taken. Your Lordship kindly come to the notification made by the state government, page 48 of the application.
Forty-eight.
48.
Yes.
Third paragraph, fourth paragraph, whereas additional director, Kolkata zone, Transport Directorate, West Bengal, and Chairman RTA Kolkata region, vide memo number such and such, stated that 20 permit holders, the enhanced permit strength against notification number such and such, applied for diversion of the route as Hathiara to SDF, avoiding CBT. Diversion. May I put this question to myself? Has the division bench said Hathiara to SDF? My Lord Justice Pratik Prakash Banerjee only indicated that variation of the route. That means the route is the same, variation. Motor Vehicles Act.
In the notification, the route is not mentioned at all.
Yes, yes. Hathiara to SDF. Then, my Lord, your Lordship kindly come to next page, page 49. This is the route. Page 49, your Lordship kindly come.
Hathiara bus stand to Salt Lake Sector 5.
Yes. Now, your Lordship kindly see what is the judgment of our High Court Division Bench. Variation of the route between Hathiara and Satragachi. Page 90 of the writ petition.
This is January 13, 2023.
Yes.
Page 86 says said routes. What is the said routes?
30C and 30C/1.
The route.
Route.
The places.
Places.
Initiation and termination.
Yes, Hathiara and Central Bus Terminus, Bandstand. Now it is Satragachi. Because Bandstand is being obliterated as per the judgment of the Supreme Court. Matter is going on before other bench. All bus stands in Bandstand as well as the Dharmatala now is being shifted to Satragachi.
Yes.
Probably, I believe this matter also come across your Lordship's court or not, I do not know. But it is being going on in the division, before the Honorable Division Bench, before the two Honorable Division Benches. That's why this has been done, because now bandstand cannot be used. Those who are using. Now all the buses which have been granted by the ST or RTA, State Transport Authority, or by the regional transport authorities, Calcutta, North 24 Pargana, South 24 Pargana, whatever it may be, that passes through, not through the central business district, but through Shialda station, then APC Road flyover, then to this Hastings, second Hooghly Bridge, Vidyasagar Setu, and to Howrah. That's the usual route. And usual terminus is Satragachi. That is the central bus terminus at Satragachi.
And the writ petition pertains to the new route.
This writ petition
Pertains to the new
New
route.
route.
Yes. That is 30C/2.
30C/2. That's not the judgment of the High Court. High Court did not say formulation of a new route. That can be formulated by the state government on their own. But for that reason, they cannot take the shelter of the High Court. And they cannot take the notification which has been already been set aside by the High Court. And also, they cannot enhance, they cannot fix the fleet stand by exercising their power under section 71(3)(a). They have no power under section 71(3)(a).
So in substance, you say that the writ petition.
These persons, now you'll also can see, they have made their application in the route in question on the basis of the notification dated 10th February 2023. This notification, whether this notification is good, bad, or indifferent, that is different aspect. Now the question is whether they are necessary or proper parties. In the writ petition, which have been challenged, the initiation of the proceedings itself, formulation.
They have applied in the new route 30C/2.
Yes. Because that is the notification.
The judgment says they can apply for diverse routes, for diversifying their routes.
No, judgment says they can seek variation of the route.
Variation means that gives rise to 30C/2, isn't it?
No. Variation is specific. Your lordship kindly see 80 subsection 3. Variation indicates under the motor vehicle set specific things.
Subsection 3.
3. An application to seek to vary the condition of any permit other than temporary permit by inclusion of a new route or routes or a new area, or by altering the route or routes or area covered by it, or in case of a stage carriage permit by increasing number of trips above specified the maximum, or by variation, extension, or curtailment of the route or routes or the area specified in the permit, shall be treated as an application for the grant of new permit, provided that it shall not be necessary so to treat an application made by the holder of stage carriage permit who provides only service on any route to increase the frequency of the service so provided without any increase in the number of vehicles. Provided further that in case of variation, the termini shall not be altered, and the distance covered by the variation shall not exceed 24 kilometers. That means, my lord, both the termini, starting point and end point,
cannot be altered,
will be same, and the middle portion can be changed.
But here the terminal is being altered.
A new route has been formulated. One termini is there, one terminus is there, another terminus has been changed. The division bench said that the variation can be done. Pilot Justice Pradeep Prakash Banerjee indicated only variation.
Yes.
Without specifying anything. Variation of the route. Route means 30C and 30C/1. Nothing more, nothing else. Now, Pilot Justice Dipankar Datta gone far beyond. His lordship indicated that yes, variation in between Hathiara and Satragachi by aligning the route in such manner. So, his lordship has indicated the manner in which the variation has to be done. Now, what the government has done? This is the issue here. What the government has been done. Government has been taken the shelter, and moreover, the RTA has formulated the route, which as RTA has no power. Here, entire notification has been made by the RTA. Government has only published the notification. Entire formulation has been done by the RTA. Now your lordship kindly see, now in respect of this addition of party, these persons made the applications. Even if I accept that the resolution has been taken, that they will be accommodated. But accommodation means subject to their qualification, fulfillment of the qualification as indicated in the Motor Vehicles Act. Now, had it been a case, on the last occasion also I have said, had it been a case that they have obtained the permit, that permit, good, bad, indifferent, High Court has cancelled, High Court has asked them to accommodate them. Now they have been accommodated instead of A route, B route. Deleting A route, they have been accommodated in B route. That could have been, because A route permit has been cancelled, B route permit has been given. In place of A, B route is being given. No new application, no formulation, nothing is required. Because for variation, no formulation is required. If I want to vary my route, because if the route is established, I can vary my route. If the route is not established, I cannot vary my route also. And route has to be established by the government under section 68(3) CA, not by anybody else.
What is your prayer in the writ petition? Cancellation of the resolution.
Resolution. Now, your lordship kindly see, in this aspect, the addition of party, who are the necessary and proper party, the Honorable Supreme Court, as far as back in 1963, delivered a decision of a 4-bench decision. It is Joseph Within. Your lordship kindly see, Udit Narayan. Your lordship kindly see, paragraph 1, 2, 6, 7, and 9. I shall place these paragraphs only. The appeal by special leave is directed against the order of the High Court of Judicature at Patna, rejecting in limine an application for a writ of certiorari filed under Article 226 of the Constitution. The facts giving rise to this appeal may be briefed as stated. There is a country liquor shop in Dumka town. Originally, one Hariprasad Shaw was the licensee of that shop, but this license was cancelled by the excise authorities. Thereupon, a notice was issued by inviting application for settlement of the shop. One Jodu Maji, along with others, applied for license on 22nd March 1961 for settlement of the shop. A lots were drawn by the Deputy Commissioner Santal Parganas, and the draw was in favor of Jodu Maji. But Hariprasad Shaw, that is the previous licensee, filed an appeal against the order of the Deputy Commissioner before the Commissioner of the Santal Parganas, and as it was dismissed, he moved the Board of Revenue Bihar and obtained a stay of the settlement of the said shop. On July 13, 1961, the Board of Revenue dismissed the petition filed by Hariprasad Shaw. Meanwhile, Jodu Maji died. And when the fact was brought to the notice of the Deputy Commissioner, he decided to hold a fresh lot on June 19, 1961, and the lot was drawn in favor of the appellant. Hariprasad Shaw filed a petition in the Revenue Court and obtained a stay of the settlement of the shop in favor of the appellant. Meanwhile, one Basantilal Bhagat filed an application under Article 226 of the Constitution in the High Court at Patna and obtained an interim stay. But he withdrew his application on September 8, 1961. The petition filed by Hariprasad Shaw was dismissed by the Board of Revenue on July 13, 1961. On 11/9/1961, the appellant furnished the security and the shop was settled on him and the license was issued in his name. After the expiry of the period of the said license, it was renewed in his favor for 1962. On June 19, 1961, one Podun Maji, son of Jodu Maji, filed a petition before the Deputy Commissioner for substituting his name in place of his father on the basis of the lot drawn in favor of his father. The Deputy Commissioner rejected the application and Podhan Maji preferred an appeal against the order to the Commissioner of Excise. The Commissioner remanded the case to Deputy Commissioner to consider the fitness of Podhan Maji to get this license and to consider whether the provisions of Rule 145 of the Excise Manual Volume 2 would apply to the facts of this case. 1. Bhagavan Rajak, who was not an applicant before the Deputy Commissioner, filed an application before the Commissioner alleging that there should have been a fresh advertisement for the settlement of the shop according to Clause 13 of Rule 101 of the Excise Manual Volume 3. On March 13, 1962, the Commissioner allowed his application and directed the Deputy Commissioner to take the steps for fresh settlement of the shop in accordance with the rules. Against the said order, the appellant filed the petition before the Board of Revenue, and the said board, by its order dated May 30, 1962, dismissed the petitions. Pradhan Maji was unfit to hold the license and directed that unless the Deputy Commissioner came to a definite conclusion that Pradhan Maji was unfit to hold the license, he should be selected as a licensee in accordance with the Rule 145 of the Excise Manual Volume 2. The result of the said Commissioner proceeding is that appellant's license was cancelled and the Deputy Commissioner was directed to hold a fresh settlement after giving preferential treatment to Pradhan Maji. The appellant filed a petition under Article 226 of the Constitution in the High Court at Patna to cast the said order. Neither Pradhan Maji nor Bhagavan Rajak, in whose favor the Board of Revenue decided the petition, was made a party. It is reported to us that the pursuant to the order of the Board of Revenue, the Deputy Commissioner made an inquiry, came to the conclusion that the Pradhan Maji was not fit to be selected for grant of license, and he was not yet made a fresh settlement in view of the pendency of the present appeal. Now, your Lordship, kindly go to paragraph 6. The question is whether a writ, no, it is not necessary. Writ in the nature of mandamus is not required. Now, your Lordship, kindly come to paragraph 9. The next question is whether the parties whose rights are directly affected are the necessary parties to a writ petition to quash the order of a tribunal. As we have seen, the tribunal or the authority performs a judicial or quasi-judicial act after hearing parties. Its order affects the rights of one of or others of the parties before it. In a writ of certiorari, the defeated party seeks to quash the order issued by the tribunal in favor of the successful party. How can a high court vacate the said order without the successful party being before it? Without the presence of the successful party, the high court cannot issue substantial order affecting the right. Any or that may be sued behind the back of such a party can be ignored by the said party, with the result that the tribunal order would be quashed, but the right vested in that party by the wrong order of the tribunal would continue to be effective. Such a party, therefore, is a necessary party, and a petition filed for the issue of a writ of certiorari without making him party or without impleading him subsequently, if allowed by the court, would certainly be incompetent. A party whose interests are directly affected is therefore necessary party. Now, your Lordship, kindly see, pausing here, may I put this question to myself? Here, no interest has been created in their favor. They made the application. Application has not yet been considered under section 80. No decision has been taken whether at all they will grant the permit or not. If had it been a case, authority have already taken decision that yes, these persons have been made the application, they are long time sufferer. Immediately, the decision has been taken in the month of February or in the month of March. Offer letter would be issued in their favor. Only 2 lines decision is required. If that is there, I am out of court.
They have a cause of action.
I have out of court. I ought not raise any question without implementing the party. As your lordship has seen, that while I move 30C petition, route number 30C and 30C by 1, at that time the permits were issued. I got only 5 persons' name. 5 have been impleted. Only 5 permits have been cancelled. And but the funny thing is this, while the matter came up before the appeal, then I prayed for, then I got all the 20 names. Then I prayed for the interim order against all these. Then the Honorable Division Bench opined, they are not parties. How can we pass such an order? They have right accrued in their favor. They are plying their vehicle. You brought them parties. Then I made the application. I brought them party. Then the division bench passed the order. All permits cancelled. Prior to that, no such order was passed. And no interim order also passed for stopping the plying of the vehicle. And your lordship can say, as soon as a right is accrued in favor of some person, either by taking decision by the authority. Suppose today High Court passed an order. So, your lordship can see, as Mr. Nondi moved a writ petition in respect of that person before your lordship.
Mr. Chatterjee, you will take some more time, I believe. I can. So, will you continue some other day? All the other matters are waiting. Actually.
As your lordship pleases.
Because I have to take up hearing matters.
Yes.
So,
and your lordship kindly extend my interim order because that is up to 31st August. Thank you.
Shorter period.
Whatever it may be, I am not asking for 1 week after the vacation. I am not asked for that. Your lordship kindly fix the matter. When your lordship will fix the matter, 1 week thereafter only.
For learned counsel for the petition. Paragraph, let the matter appear under the same heading for further consideration. 18th September.
18th September.
18th September.
Yes.
Paragraph, the interim order granted earlier is extended till 30th September. All further orders.
My lord. সোমবার আরে 18 সেপ্টেম্বর বিশ্ব বুঝি 17 তারিখ বিশ্ব না স্যার 18 তারিখ ও আমাদের তো 18 তারিখে 19 তারিখ করে my learned friend হ্যাঁ আমার ড্রাইভার আছে খুব অসুবিধা স্যার my lord instead of 18th let it be 19th because 18th is a Vishwakarma puja our driver may take leave.
Yes,
my lord. That in this year, 18th is Vishwakarma.
17th should be.
No, my lord.
Yes, usually 17th, but this year it has been shifted to 18th.
Yes.
18th.
Strange, this never happens.
This never happens, but this year it has happened.
Oh.
And our driver may take leave.
Very well. Let it be 20th.
20th.
Let us be on the safer side.
Yes, it's 20th. Interim order till 30th.
31st. 30th September. Yes.
Fine.
That's 20th. 20. Date 20. 20.
I am for the petition, my lord. By the order dated. By the order dated 12th of May 2023, your lordship asked for.
Mr. Naik for the.
Yes, my lord. Twice they prayed for extension of time to file report. On 14/6 and 24/7.
Where is? Mr. Naik and is Rituparna Moitro. She is also not there. They are not in the panel. Mr. Naik is also not in the panel. Oh, seem to serve a fresh notice. They are not in the panel now.
May I on leave I have prayed, may I file a supplement affidavit? I shall file also this input.
Supplementary affidavit submitted on behalf of the petitioners is taken on record. Paragraph, none appears for the respondents. Paragraph, since there has been a change of learned counsels in the panel.
Item number 184, my lord.
184, yes.
184, my lord. Mr. Naik is for the state, my lord. My lord, we got the report yesterday, my lord. But it is not affirmed, my lord.
Mr. Naik is still in the panel?
Yes, my lord. He is in the panel, my lord.
Okay. Where is the report, sir? You've taken
My
two
lord,
extensions
it is not, my lord, affirmed. That's why I'm praying for 2 weeks time. My lord.
taken two extensions already. Please be ready on the next occasion.
Yes, my lord. I will
Mr.
definitely.
Shubhra, no need to serve further notice. He says there, he's in the panel. File the report in form, to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on
Next week, your lordship, I've been waiting since June, 14th of June, your lordship.
12th September.
I have served the copy of this affidavit with my lordship.
Pardon?
This is my time for the petitioner, my lord. My lord, the state has filed one report, my lord. I want to take exception to the same.
Today?
Yes. Copy was served on Friday.
Report in the form of affidavit. Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the said report. Paragraph, let the matter appear under the same heading on 19th September. Please serve an advance copy.
Yes, yes, ma'am. Yes.
Lordship, I am for the petition. Matter relates to registration of e-vehicles, Lordship.
Matter relates to
Registration of
e-vehicles.
e-vehicles manufactured by petitioner.
So there must be an application on Mr. Sinha's party.
Party here, respondent 6, Lordship.
State.
My lord, by recording my submission,
Where is Mr. Sen? Mr. Sen is appearing in this matter. His junior can be here. His junior.
Junior care.
Who is appearing as his junior? You're appearing. So let a similar order be passed. It's an e-rickshaw case. Yes, the notification, the memos have been challenged.
Lordship.
Mr. Sinha?
my lord, my submission may be taken on record and similar order may be passed. That is my humble submission. My submission is to the effect that I don't have the patent over any battery. I am having the patent over the technology, as mentioned at page number 89 of the writ petition.
Yeah.
Thank you.
Welcome.
You're holder of a patent.
Patent on a technology, my lord, as mentioned in the injunction order. My submission may be taken on record and similar order may be passed. That is my humble submission.
Where is the earlier order?
Lordship, page 190, Lordship. No. Copies of the solemn order passed on.
190 is not the order.
No, my lord.
Mr. Sen, again e-rickshaw.
Let it be continued.
Not over as yet. More
think-
e-rickshaws are there.
I think at least, my lord, some e-rickshaws be, my lord, regularized in this way. At least, because, my lord,
Should be.
more than 2 lakhs, or more than 3 lakhs unregistered. So at least in this way, some registered e-rickshaw be applied, I think.
May God bless my learned friend regarding this submission, my lord. This will bring a good legality in the field of e-rickshaws, my lord, because all are plying unregistered.
ও তো বাধা দিচ্ছে না।
না, আমি তো God bless বললাম।
ও হচ্ছে সব কেউ আছে তাই।
Lordship, in the present writ petition, I don't, not there, but
blessing
on the next matter, it is annexed, Lordship, I find.
আপনার blessing.
In the next matter.
Or
Let me call. the
I shall supply, I shall call my clerk and shall supply.
Next matter to be.
I'm sorry.
Next matter to be.
Same here.
না অর্ডারটা কোনোভাবে খুঁজে পাচ্ছি না এর মধ্যে অনেক তো করা হয়েছিল হয়ে গেল।
My lord, the order copy printout.
না না প্রিন্ট আউটটা নেই না না আছে আছে এর মধ্যে অ্যানেক্স করা আছে।
হ্যাঁ একই সাথে হবে একই হবে।
Lordship at page 269 I am sorry Lordship page 269
চাইছোটা কোনটা যে ওই
অর্ডারটা অ্যানেক্স করেছি
আগে যে অর্ডার হয়েছে তাই তো
হ্যাঁ
রেজিস্ট্রেশন
হ্যাঁ at page 269 one.
No, 269 is not the order.
Lordship
269 is not the order.
high tech
286.
one double three eight
186 order হবে।
My lord, I am grateful for assisting us on this side also. This 286 must be come from us.
Her learned counsels for the parties.
কিভাবে সাজিয়েছে কে জানে
ডাইরেক্ট রেজিস্টারিং অথরিটির উপরে না আবার ডিরেক্ট
The memos.
দেখি আর এরপর অনেক অর্ডার হয়েছে ভুল করছো দাও দাও দাও
The memos
286
issued
এটা
on
করেনি
13
রেজিস্ট্রিং
January
অথরিটিটা
2022
করেছে
and 13
My lord,
July
286 বললেন
2022 are
এটা নাই এটা নাই
have been assumed by the
এখন রেজিস্ট্রিং
petitioner
অথরিটির উপরেই
at
হচ্ছে
the present
286 হচ্ছে
286
তাহলে এটা কোনটা
না না 286 পেজ
The memo dated
Yeah,
13
order
January
done
2022 restricts
order done
registration
for
of battery-operated eco-friendly e-rickshaws in terms of the order passed in title suit number 27 of 2018 by the learned Additional District Judge 13th Court Alipur on 24th February 2020. Stop. The said order restrains the authority from registering the battery-operated eco-friendly e-rickshaw till disposal of the suit. Page 286 পাবেন 187
হ্যাঁ এর আগে
187 page 286
আগেরটা কপি
Paragraph, the memo dated 13 July
বার
2022
করতে বললাম
allows registration of e-rickshaws manufactured by Messrs. Mahindra and Mahindra Limited. Paragraph, it is submitted on behalf of the petitioner that the battery manufactured by the petitioner is lead cell battery, which is distinct and different from the battery manufactured by the plaintiff in the title suit. Paragraph, learned counsel for the sixth respondent. Sixth respondent submits that
হ্যাঁ হ্যাঁ 6
he is the holder of a patent in respect of the technology applied for battery operated rickshaws.
not
and
over any kind of battery my lord
And not of any particular class of battery.
my lord as mentioned in page 89 of the writ petition
Yes.
ওটা তোমারই পিটিশন
no sir এটা না
লাস্ট এটা হয়েছিল
Paragraph. A coordinate bench of this court, comma. In an order passed on 16 February 2022 in WPA 2070 of 2022, comma, has dealt with a similar issue and has directed the transport
করে নিয়ে আসতাম
আরে আমি তো ডাইরেক্ট
কি দেখাচ্ছ
directorate, comma, Government of West Bengal. It's 287 থেকে পুরোটাই একই হবে, নিয়ে নেবেন? 287 কিন্তু second matter.
My lord, practically speaking, my lord, for last several occasion, my lord was kind enough to direct the concerned registering authority, not the director. And because initially that was the order, my lord, used to be passed, that the director transport should issue the letter. Thereafter, my lord, it is modified by your lordship on the basis of my submission, that the concerned registering authority be approached directly with regard to that registration purpose.
So are the registering authorities part of the, are they implemented as parties?
My lord,
no my lord
no
is earlier practice was lordship was director was issuing memo
No. After that, he does not know. After that, it was modified.
Yes.
It was modified. Instead of that cumbersome procedure, so let the particular registering authority be approved by the person concerned.
In earlier matter, after your lordship,
তুমি অবিশ্বাস করছো?
কত পেজ বললো?
তাহলে কি মেটারটা ইস্যু হবে না?
না, কেন হবে? ডাইরেক্ট অর্ডার হয়েছে। ডিরেক্টর কি করবে?
Add him, add him. add the
Director has
listing
nothing to do with the registration, my lord.
add the
Lordship,
listing
kindly see, after your lordship has passed order to the director, director has issued memo directing all registering authorities.
After that, my lord, there was, my lord, several, my lord, anomalies, and that is why, my lord, the director's letter does not match with my lord's order. Then, my lord, he, my lord, preferred, yes,
There were
then that was brought to
there
my
were
lord's,
some complications.
Yes.
for which
So why this?
subsequently orders were issued upon the
Because they know that which
Registering
registering
authorities.
authority they have to be approved.
Lordship on,
My lord, I am not having any objection with my learned friend's submission.
lordship on
Let me
23rd,
order
on
open the registering
23rd,
authority.
your lordship has also directed director.
Registering authorities.
What director has to do? Director has nothing to do.
Who are the registering authorities in this, in the first writ petition? 186.
Lordship,
Who is the registering authority? Which area? Which region?
আচ্ছা বাবা, প্লিজ না অ্যাড করে দিন। আপনি add করে দেবেন।
it is difficult to add all the registering authorities. I am praying for your lordship to pass an order upon the director. He will issue, it is better. Otherwise, it is very difficult to add all registering authorities, lordship. Lordship has passed on 23rd also.
No,
Directing
why?
the
Why
registrar-
not registering authority, the
Directing the
person
director,
concerned,
lordship.
some people,
Now,
lordship,
in the mid,
he
if
knows that-
it is
that
changed,
which
then
registering authority is the
petitioner will be in
particular
great
registering
difficulty. Petitioner will be in great difficulty.
He should know that which registering authority. he
Lordship,
should
I
be
have done
approached.
many matters. I have, don't find
This is
any allegation on my part of my client that
May not
say,
have the allegation. Mr. Sinha had come up with other writ petitions.
Yes.
No, I will not come, my lord. I am agreeable with my learned friend's proposition, my lord.
Lordship,
I am on this side.
Lordship, kindly direct the director. This is my humble prayer.
No.
Your lordship has directed on the last occasion,
That
third also.
change.
I have
On
After
several occasions
23rd,
after that.
after 23rd, I don't think.
Order can be passed on your, no, on the basis of his
This
sole.
is the state
submit.
authority who has to pass an order.
Because, my lord, may I
So
tell?
the state council has to be heard. And if Mrs. Sen says it has
My
to
lord,
be.
bearing, my lord, bearing in this, my lord, the auto rickshaw,
Then
I mean
lordship,
electrical auto rickshaw,
This is.
in
Hooghly.
no matter, my lord, director has never been roped with.
This is.
So the
Hooghly.
director have nothing to do.
So it should be the registering authority Hooghly.
No, lordship, office is situated at Hooghly, but all the registering authorities, he
Very
can
good, lordship,
apply.
my lord, kindly direct the concerned registering authority.
Has to be a party. He cannot come up in contempt.
This is the whole difficulty, lordship.
No, difficulty তোমরা তৈরি করছো তো।
Because I see,
অবশ্য
he
মিলে
is
তার
a
মামলা হয়।
businessman.
Authority.
Difficult
sir.
He can do business in any districts.
Concerned registering authority,
Then concerned registering authorities, lordship.
Contempt will not lie then against anyone. Please understand, sir.
But a petitioner who has come up before this court, he should, my lord, he should know that who are the appropriate respondents.
My lord,
Then
this-
lordship, kindly do one thing, kindly direct all the registering authorities in the state of West Bengal.
No, my
Because I
lord,
can
my lord, অন্য
in
জিনিস,
any district, I can apply for TC in any district.
my lord is of the view that contempt
No.
will not lie if you don't implement.
That district we write, we put the district where our office is situated, but that doesn't mean I do my business, I restrict my business in one district only. My office may be in Hooghly, but I can try my luck in Coachbihar also. I shall apply for TC. I will be granted. Thereafter, I can establish my showrooms there. So all registering authorities in West Bengal should be.
My lord,
Should be
very well, if
directed.
my learned friend
So-
doesn't want to
so,
file contempt, I will file the contempt.
So
Is this.
what my
Petition
prayer
has
is,
been filed.
better lordship,
Mere apprehension that I have to approach some district, I think registering authority, they may.
because,
refuse,
without TC,
and
I
then
cannot do business.
the entire writ
Without
petition is
TC,
a
I-
mere apprehension. Has it been against any order or against any specific refusal, then there should have been a specific respondent authority.
No, no, the two
Yeah.
memos are challenged. No particular registering authority has issued the memos, isn't it?
No, memo has been issued by the director on the basis of that particular minor, the situation of that
Yes,
order.
yes.
Then now the situation is now changed. Now, my lord.
Nothing has been changed,
Now-
my lord, nothing
now
has been
either
changed.
he made, my lord, the specific
Not
some registering
changed.
authorities.
Then in that case, the entire, all the state registering authorities have to be impleted.
Let him implement.
Mr. Sen, that will be a
But
very
otherwise,
difficult task.
director.
Lordship, that
my
will
lord,
be
kindly
very
consider.
difficult to serve upon
Then
them.
again,
Yes, sir.
my lord, kindly consider, director has nothing to do with the function of the registering authorities right now, so far the registration
But the
is
director
concerned.
can direct all the registering authorities.
My lord,
He
may
has
I
no-
tell,
he
my
has
lord,
no
my
direct
lord,
function.
my lord, because of that, the earlier order was there. After that, when my lord was kind enough to pass that order, my lord directing the director transfer it to my lord to issue this letter. Now, my lord, eventually it appears on the basis of his submission and or that particular letter produced for your lordship, that it does not match with my lord's order.
That is the director's fault, Mr. Sen. He has to file, he has to issue a direction in terms of the order in toto. He cannot
But
make his own orders.
subsequently, my lord, on the basis
And
of
several
this, that-
memos have been issued, lordship.
no,
No, what? I have annexed.
আরে ভাই তুমি অনেক পুরোনো দিনের কথা বলছো। Subsequently, when it brought to my lord's
50 বছর
notice,
আগে।
now my lord, that there is no need to pass that order, my lord, hoping the director, let him approach the registering authority. And if your lordship, my lord, direct that the concerned registering authority,
Sen, it is very difficult to implement all the registering authorities.
I do not
of-
want it, I do not want it. If your lordship, my lord, if it is indicated in your lordship's order that the concerned registering
Then
authority,
suppose the order is not complied with, who will be held responsible?
my lord, the concerned registering authority means, may I tell you, good lords, you, under the law, my lord, suppose there are, my lord, jurisdictional, all the registering authority, they do their work in their respective jurisdiction. Now, the concerned registering authority, bhai, tumi jodi shobi jano tale to hoye gelo. Now, the concerned registering authority means the respective jurisdictional registering authority before whom, my lord, the particular writ petitioner may approach. Lordship, kindly consider, if it is in Howrah district, then the registering authority of Howrah, or maybe a sub-registered under the
In
Howrah.
that case, all the registering authorities of all the districts have to be impleted. Because I have to allow the.
Not
petitioner
necessary, so far my knowledge goes, lordship.
has to, do his business all throughout.
Only thing, my lord, if it is a contempt, suppose, my lord, for abandoned application, suppose my lord order is not complied with,
Yes.
if it is a contempt, then my lord, only thing, the petitioner in a contempt petition, he has to satisfy your lordship that the authority before whom he has approached for this purpose, he is the particular registering authority. Otherwise, he is authorized to do the same.
And if he is not a party to the writ petition at all, then
Even then, lordship, my humble submission, because, my lord, may I tell, my lord, when my lord, if the order is passed, my lord, judgment in rem, judgment in personam. If it is, my lord, in rem to that extent, that roping all the concerned authorities who is otherwise or who are otherwise, my lord, eligible and authorized to do the same. Because at the same time, two registering authority has no power. At the same time, my lord, two registering authority has no power, either of the same.
can you show me an order of issuing a direction upon the concerned registering authority?
My lord,
Lordship, I have
right
annexed.
now I have no, my lord,
Matter tomorrow in that case.
Lordship, I have annexed at page 291.
Of,
There, one memo has been issued. on
that is separate thing.
that's a memo, that's a different issue. Because I distinctly remember that the later petitions were all directions upon.
My
the
lord, Mr. Enai Khan, I think, Enai Khan can assist us.
My
Where
lord,
is
my lord, in some of the matter, directors are directed, director has been directed, and in some of the matter, registering authority we are directed.
registering authorities are made parties.
My lord, and director taken up the whole of the matter that is under challenge before your lordship and passed an order. So there is two contempt applications were also pending in this matter, my lord. My lord, I think that is why my learned friend is making apprehension about the director. My lord, whatever your lordship may deem fit, may kindly pass the order.
I'd like to see an order directing the registering authority.
My lord, I will bring that copy tomorrow.
Otherwise, my lord, may I tell, my lord? My lord, he may come tomorrow or day after tomorrow. That the my lord's order has not been followed in toto in this way or that way.
The director follows the order.
I am not
in
on that.
toto.
I am not.
There is no question. of
Just, my
contempt.
lord, may I tell you? For a
Contempt
question, my lord,
does not arise for so many issues.
who will do this job? May I tell you? Who will do this job? The registering authority.
The director will issue a general direction about
That
the
Already
registering
issued in
That-
several matters, Lordship.
That
I have annexed at
that
page
be quashed.
291.
That be quashed. Because when the director issued that, because of that pending civil suit filed by his.
No. This court in the writ petition will direct the director to
Right.
issue a blanket order to all the registering authorities. That will solve the issue.
My lord,
Already
because earlier
issued.
memo
I have
was
annexed,
issued by the
Lordship.
director itself.
The
So,
memo is in terms of the order, then there's no question of.
No question of
violation.
contempt.
my lord, the memo under
That will be done, because otherwise it will
My
be
lord,
very
I leave it
cumbersome.
to your lordship, my lord, I leave
It
it
will be
to your
very
lordship.
cumbersome otherwise. Just
I'm
like
grateful,
a
my lord.
Director.
I think that the
director
registering
I'm grateful,
authority.
my lord.
Yeah.
hope na.
अच्छा brief টা হারিয়ে
Yeah, chalo. Yes, the next matter. Yes.
ম্যাডাম ডাক্তার
এগুলো আছে পরপর ডেকে নিতে বলুন। 187 also same order.
Lordship 188 also
187 and 188 are
186.
186 187 188
189.
I'm grateful, man.
187 same order.
188 to same order.
188 same order.
188 to same my
ওই director তাহলে।
I'm grateful.
Same order.
I'm grateful.
Yes. Switch to hearing matters.
Mine.
Grateful.
I just.
Wrongly
Okay.
বলে আমাকে বলতে হবে।
হবে না স্যার
Wrongly বলে
7 তারিখে ফিক্সড আছে
This has been fixed on 4th, I think.
Fourth.
So please come back on.
Yes, no, we will come back on fourth.
It's a wrong entry. in
Yes,
this.
yes. That's. So let there be a marking on fourth, my lord.
Yes. Maybe 4th to 3:30.
Lordship, item 202, your lordship, I am for the petition, your lordship. Ek to say, no?
Respondents,
Lordship, the respondent, your lordship, which has been served, affidavits have been completed, your lordship. It's a very short matter, your lordship, may I just.
let me
Yes.
see. Second.
Other affidavit in reply, वापस आ गया था, रुके हैं।
Affidavits are exchanged.
Affidavit is exchanged, we have filed our
I-
affidavit in
It's
reply.
nothing on record
May I file my affidavit in reply? Your lordship?
about the opposition.
It has been served, your lordship, to the office.
It's not filed.
Maybe your lordship, the other side, your lordship has not given the affidavit. We can, your lordship, give your lordship our copy, your lordship, of the affidavit in opposition. At a copy, though, please give in opposition. Opposition judge.
Ms. Sucharita Vishwas was appearing.
Yes, your lordship. She was appearing, she has given your lordship a affidavit in opposition
I
to
need
us.
the original copy, sir,
Yes, I understand, your lordship, but
because she has to be there.
No, she's purposely not appearing last time.
lordship, there is actually in affidavit, nothing is there. So maybe your lordship, this wish,
Something or nothing, the respondents have to be represented.
she should come, your lordship.
Did you put them on notice?
Yes, this, there was the notice, your lordship.
Because hearing the matter in their absence will really not serve your purpose, isn't it?
My lord, on the
It's
last
the
couple
law.
of occasions, the matter was taken up by my lord. On twice only, my lord, she has taken an adjournment on personal ground. One day she said that she didn't. She had some problem.
Yes, Mr. Roy, your lordship is on.
Last time Mr. Roy had.
My lord,
Order.
my lord, may
Mr.
I
Roy
just make
is
one formal request, my lord? My lord, this has been going on for some time now. My lord, let us give her one last notice. Your lordship will tell her, then tomorrow, my lord, takes it up and disposes of whether she appears or not. My lord, this is now, my lord, our client is also a senior citizen, my lord. Kindly appreciates, my lord. I have taken the pains of appearing before your lordship. Your lordship has accommodated me. But at every instance, my lord, we are getting this from the other side that they're going to take time, my lord. My lord, let me give them a notice for your lordship once. I'll give them a notice once more for tomorrow. If they don't appear, my lord, let us just proceed, my lord. I'm beseeching your lordship, my lord.
Because it will really not serve your purpose if I hear the matter in their absence, isn't it?
My lord, I do appreciate, but if they don't choose to appear, my lord, then, my lord, I will have a point that I have to move ex parte, my lord. And my lord, I'm asking for a very small innocuous prayer because this needs to go back for the person to reconsider and get it back. Because the person was supposed to decide on my mutation. He decides on my title. Completely contrary to the requirements of your lordship's order, the first order. So, my lord, it has to go back. So, for this small innocuous prayer, my lord, we have been running from pillar to post and she is not going to appear, my lord. I generally don't make complaints, my lord.
For absence, it will be taken up on the next date. I'll record that. None appears for the respondents. Paragraph affidavit in opposition is not filed. Paragraph affidavit in reply submitted on behalf of the petitioner is taken on record. Paragraph let the matter appear under the same heading on 6th September.
My lord, we'll give a notice in the meantime. My lord. Let it retain its position, my lord. It's pretty high up in the list, my lord. I'll just request you,
It will. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
I'm very grateful, my lord, and kindly does not take me amiss, my lord. I generally don't do this, but don't have a choice, my lord. Kindly, my lord.
Come back, please. Let me see.
Very, my lord, we'll do that. I'm very grateful.
So only one prayer, your lordship.
Bolo, bolo.
Lordship, only one thing, your lordship, let the matter, your lordship, retain its own position. Otherwise, your lordship.
I hope it will.
Lordship.
2022 matter, they're fairly at the top. আচ্ছা এর আগে 3:30টা কবে কবে দিলাম 4 তো 4 আগেরটা fairly at the top, huh? Three. Yes, 203.
He's coming. He's on the way.
Petitioner is not there.
But he's coming.
Respondents are also not there. No one. None appears. Let the matter appear in the monthly list of September 2023.
My lord, Advocate Devaswar is on the way. Kindly.
On the bill is not considered in this court, sir. I'm sorry. Next matter.
I am for the petitioner.
Yes.
My lord, last occasion, my lord,
Affidavit 16.
initially direction was there, my lord, in the year 2018. Therefore, matter appeared as warning list. Now, nobody appeared. The learned advocate who appeared, my lord, was directed to notify, my lord, notified twice, didn't appear.
You are for the petitioner?
I'm for the petition. I served, my lord, upon all the respondents. My last occasion, my lord, when I served the GP, my lord, as per lordship direction, my lord, Mr. Soumitra Bandyopadhyay appeared, and my lord, lordship extended the time for filing affidavit.
Yes, where is that?
Today my brief is not with me, my lord.
The 31st March, my lord, direction was given.
31st March, we are in August, end of August.
Actually, Mr. Bandopadhyay has not come today, my lord. Let it be adjourned and আমি নোট করে রাখছি আপনি এফিডেভিটের ডিরেকশন ছিল
31st March. My lord, may I come back, my lord, after tomorrow, my lord? Because my lord, issue is settled. My lord, order passed by this tribunal, this your lordship, my lord. In other matter, my lord, I have the copy, my lord. Only this order, my lord, quantify, my lord. My lord, the concerned BLLRO, my lord, is asking for, my lord, paying royalty. You know, paying royalty and will be decided, my lord, on the basis of the quantum of the sand and, my lord, the bricks. Now, my lord, that, in other matter, lordship directed, my lord, the BLLRO to give to notify the parties, make an inquiry, quantify the sand, only upon which, my lord, the royalty and says, my lord, would be determinable, my lord, at the rate of ₹15.
Let the affidavits come.
Well, affidavit, my lord, 2018, my lord, we are after 5 years.
I'll give
In the mean, let Mr. Bandopadhyay come, my lord.
Next month, I'll give.
My lord, next month, my lord,
Let's just be ready with the affidavit. Only Mr. Bandopadhyay is coming will not
আজকে তো
help.
28 হয়ে গেল
Learned counsel for the respondents. No, and the other respondents also, only state
Only state.
seeks extension of time to submit the affidavit in opposition as sought. Paragraph, let the matter appear under the same heading on 18th September. Sufficient time, please.
Well, make it last chance then, my lord. Make it last chance. Enough time was given.
Next,
একটু রিডটা দেখবেন 103 মেলা উইল টেক আপ
105.
No, I'm for the petitioner.
Yes.
No, this is that matter, my lord, wherein the letter issued by the respondent authority is asking for transfer fees, my lord. My lord, plot of land at Salt Lake, my lord, bequeathed,
Affidavits exchanged.
affidavits exchanged, my lord. The matter lastly appeared on 23rd of November 2022.
Yes.
My lord, when I had pointed that the state respondent in their affidavit affirmed on oath had stated that certain matters are pending before the Honorable Division Bench. In reply, my lord, I had pointed out that that matter has already been dismissed. That order has also been annexed in my affidavit in reply. On that pretext, the lordship had asked them as to why on oath a wrong statement has been made, and for that, the state respondent had taken time for taking instruction, my lord. But I have also given today notice to the
For the state.
Mr. Sudadev Vadak. Today also I have given him notice, my lord, to appear, my lord, when the matter will be taken by your lordship. So similar,
He has been appearing all through.
he has been appearing, my lord, and the notice, my lord, I have also given and mentioning,
Please serve a further notice. It's not that he has not been appearing. He has been appearing also.
my lord. My lord, kindly fix the date, my lord, and fairly on top.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 20th September.
20, grateful.
Paragraph, the petitioners are directed to serve notice upon the respondents intimating the adjourned date.
My lord.
This is also a matter like that, my lord, where my lord, the learned advocate for the state is changed, my lord. So
It is
changed, my lord. He's
state to serve.
my lord, in the initial stage we have served everyone.
Now there's a change of change in panel.
So I have
Serve and come back. None appears for the state respondents. Paragraph, since there has been a change of learned counsels in the state panel, comma, the petitioner is directed to serve fresh notice upon the office of the learned government figure and file affidavit of service on the agenda.
On the private respondent also. Because my lord, it was served in 2019, my lord.
Serve afresh. The petitioners are directed to serve afresh upon the respondents and file affidavit of service on the agenda. Paragraph, let the matter appear under the same heading on 20th September. 20th September.
Another matter, your lordship fixed on 14th, my lord. So, my lord, can that be, my lord, on
14th is a Thursday.
20th?
Wrongly fixed in that case. 14th is a Thursday, original side date.
My lord.
Here, 20.
20th September.
20.
20.
I'm for the state, my lord.
Affidavit. Once copy so that reply can be filed.
My lord, 25th. 25th.
Question appearing for the petitioner, your lordship.
I'm for the statement.
I for the Jilla Parishad, lordship. Last occasion, court is directed to file affidavit. Opposition within such and such, lordship. Affidavit is prepared, lordship. Copy is served. Lordship, I have not filed this copy, lordship. I am paying for time, lordship. 1 week time.
Go for the state.
I'm for the state.
Jilla Parishad, lordship. Lordship, affidavit prepared.
You also, you are for?
I file a affidavit.
You are
Opposition. Jilla Parishad, lordship.
Jilla Parishad, yes.
Question on the next.
He also needs to file an affidavit. Opposition.
The same thing, same.
Lordship, we have received a copy of the affidavit. On the next day, we'll also file a reply to that affidavit.
The state.
Lordship.
Please find out.
I have to.
It has to come on record, it's not there.
State affidavit page,
Learned counsel for the respondents.
Yeah,
Extension of time. Submit affidavits to the opposition as paragraph, let the matter appear under the same heading on 25th September, the same date.
My lord, kindly say if not filed, my lord, because my learned friend is saying that it has been filed by the state.
It has not been filed. I have received a copy of that affidavit.
Filed.
It has not been filed. I have received a copy.
Okay, my lord.
Grateful.
Yes, who is appearing? $209. None appears for the petitioners. No accommodation is sought. Dismiss for default.
Lordship, in this matter, Mr. Bihani is appearing for the petitioner, Lordship. He is on legs, Lordship. I am only here for not today, Lordship.
Affidavits are exchanged.
Affidavit are not exchanged, Lordship.
Why this matter is appearing? Really? Mentioning upon mentioning yes.
Lordship, opposition is all filed, Lordship, but reply not received.
It's exchanged by Yes, opposition is filed. You have not.
Yes,
filed
yes.
Reply.
Yes, His Lordship.
Reply you have not filed.
Lordship.
Learned counsel for the petitioner seeks extension of time to use the affidavit in reply as sought. Petitioners. Paragraph, let the matter appear under the same heading on 27th September.
Grateful, Lordship.
No, this matter, my lord, unfortunately missed the brief today. Kindly accommodate for the day.
My lord,
I'm for the
but
petition.
I'm the statement I'm filing my opposition.
Though,
Affidavits are exchanged.
My copy has been served, my lord, but whether, my lord, the reply has been, no copy of the reply has been.
Reply?
no, it has been ready, my lord, today, my lord, missed the brief today. That is, my lord, the only one day accommodation.
I'll give you a date. There are other documents also. Bodwan Development Authority,
No, sir.
Shrachi Housing Development Limited, who are appearing?
আগে কি অ্যাপিয়ার করেছিল? No. No one appeared. আছে কি? No, মোটে appear করে না।
স্টেটের হয়ে অ্যাপ্লাই করেছিল স্টেটের হয়ে
Such is the recurring body.
Yes, Rishabh Datta was appearing for 5 and 6.
কি নাম?
কিশোর দত্ত
কিশোর দত্ত। কিশোর নামটা লিখে রাখো। কিশোর দত্ত তাহলে নোটিস দিন।
For Shrachi Housing Development.
This is a
Rishabh
recurring
Datta,
body.
Please inform me. What about the Bodwan Development Authority? You're appearing?
No,
Of the state.
I'm only state, madam. They are separate by a year.
Bodwan Development Authority, no one is there.
Already service has been done already.
Why don't you make a further service because 2019 matter? Yes, inform the respondents.
No, only one day. Bordhaman.
Affidavit in opposition submitted on behalf of the state respondent is taken on record. Paragraph. None appears for respondent numbers.
It is Bordhaman Development Authority. Bordhaman Development Authority not the made party.
Yes, respondent number 4. Respondent number 4.
Yes.
None appears for respondent numbers 4, 5 and 6. Paragraph, learned counsel for the petitioner seeks extension of time to use the affidavit in reply as sought. Paragraph, let the matter appear under the same heading on 25th September.
Not the so much earlier.
Paragraph, you have to serve, they have to file affidavit in opposition.
No, they have not deal the opinion opposition. That's why the reply on the state reply.
Yes, I have to give them an opportunity. It's a hearing matter.
That was direction was.
Paragraph, the petitioner is directed to serve notice upon respondent numbers 4, 5 and 6, intimating the urgent date. Please serve notice. Only notice.
Yes. 25th. Much.
And for the state ballot.
Petitioner,
Led by Mr. Rohan Banerjee.
please appearing for the petitioner.
Mr. Arun Noshkar.
Mr. A. Noshkar.
Arun Noshkar as well. Affidavit has already been exchanged, my lord.
This is 24. None appears for the petitioner, no appears. Mentioned upon urgency and then no one.
Look, 2013 and 14, two matters are there. I am 2014.
My lord, in 2013, Mr. Siddhartha Banerjee is appearing for the petitioner, my lord. He is on his legs in another court, my lord. I prefer not to refer.
These two matters, claiming the same land.
Affidavits exchanged?
Yes, my lord, I
Affidavit exchange, there.
Oh,
Who is appearing for the state?
I am filing the
There has been a private dispute raised over this. If your lordship kindly have a look, that recently we are in receipt of a letter issued by the petitioner in 2000, the first matter, that is 230. Both are claiming the same land.
No, I have my document. May I?
So this is the letter.
Lordship,
The letter we have received. I'm
Hear the matter first.
I
I have to hear the matter first.
both the matters are there. For that reason, I was.
Yes, the petitioner in the first matter is not there today.
This my lord is on his leg on another court, my lord.
You received affidavit in opposition today. Have you received a copy
Yes, I have handed the word.
in the first matter? Or is it a combined affidavit in opposition?
I don't
Yes.
know about the 214. I don't know anything about 214.
So far KMD is concerned, my lord, we have filed affidavit in opposition in both the matters.
In both the matters?
In both the matters.
Separate?
This is the letter which I ended up to your lordship. Recently we have received. This is the dispute created. So amongst themselves, they should have, that should be decided fast. Both are claiming compensation. One admits,
Both are claiming you can refer the matter.
no,
Simple.
on different set of facts. They are opposing.
It becomes easier for the authority.
No, Mara, I have document.
In one petition,
Yes, but if there is a dispute, the authority cannot pay anyone.
I'm not on that. If I can produce your lordship the documentation, the other party sold the property in 1939.
What happens? Both the parties produce documents. Can the
Can the-
authority decide?
No,
on
no.
type?
When he came to the court, he must come with clean hands. But I have come to your lordship's court with clean hands. I have my documents. I have procured the documents, my lord.
Affidavit in opposition submitted by the state respondents in WP 20903 of 2019 is taken on record. You are not in the other matter, in the, who is appearing in the second matter?
Second matter, I am for the petitioner, my lord.
State.
he is for the federal.
My lord stated, my lord, for the state, my lord. My lord, I have received affidavit
Oh, Mr. Day is appearing.
27 day.
Yes. Mr. Day is appearing.
I will inform him.
Please inform him. On prayer of the petitioner in WPO first matter to be. 20903 of 2019, the matters are adjourned. Paragraph, let the matters appear under the same heading on 20th September,
Both the matters.
both the matters.
Affidavit in opposition kept on record.
They have to establish their title
Please
first, then to
Mr. Day that he has to file an affidavit in opposition in the second matter.
Well, the second matter, affidavits are completed.
Opposition is complete.
Yes. Both the state government and the KMD file affidavit, my lord, I also reply.
May I take back the letter?
Yes.
This is what I wanted to show your lordship that they have to decide their title
That's why I
first.
said it becomes easier for the authority.
Well, I have my document. Certified copy.
Let us see what
Yes,
documents
yes.
the other
The
petitioner
land
has.
was acquired in 2 phases.
Not of that, I have obtained certified copy regarding the documentation, which they transferred in 1939.
We do not know what documents the other
Well,
petitioner
I
has.
annexed to my petition also,
Please come back, I'll deal.
my lord.
They have to settle their dispute first.
No,
Then to-
you are enjoying the game.
I am not enjoying.
We enjoyed.
What to enjoy?
15, I am for the respondents, Urban Development Department, Mala.
Petitioner,
This is my affidavit in opposition.
petitioner in 15,
Mala.
come on.
1984 plot allotted. This is 2023. 39 years ago, they did not make any construction. Land at Salt Lake. This is a short
Who's
point.
appearing for petitioner?
Most probably Mr. Noyan Chand Bihani. I get the name of Papia Bihani. So most probably Mr.
নয়নচক বিহানি 215
Anyone
জীবন দাস
wishing-
বাজার
Yes.
Yes, Lordship, for petitioner Lordship,
Yes.
he is on legs, Lordship. I am only here for not today, Lordship. Affidavit are exchanged, Lordship, in this matter.
আমি ফাইলও করে দিয়েছি এফিডেভিট
Reply,
Reply also exchange.
where is it?
May not be filed before your Lordship, but is already exchanged, Lordship.
they have given me reply my lord kindly records that I have filed my affidavit and keeps it on Wednesday I'll do it short matter
Affidavit in opposition submitted on behalf of the respondents is taken on record. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the please file your affidavit and reply on the next.
Grateful, grateful, Lordship.
he has served me
It's not on record.
he needs to file before the court
Let the matter appear under the same heading on 20th September.
Lord, I beg to appear on behalf of the petition in this matter, my lord. There was a direction for filing affidavits, but I believe
Received a
we
copy.
have not received yet. My lord,
She's appearing for the state.
state and authority, any highway authorities and state both.
NHI,
My lord, in this matter, Lordship, I am not the answering respondent, Lordship, because the competent authority Uttar Dinajpur.
file an affidavit.
But if your Lordship says, the Lordship, I think, Lordship, the entire amount has been deposited from my part.
My lord, there is certain discrepancy. I tell you, lordship. Now it has been acquisitioned. We prayed for compensation. State says it is a vested land. Highway authority says we have deposited the compensation. So there is a conflict. Now subsequently what happens there was a direction for hearing. During the pendency of the writ petition, my lord, we were called for hearing. We participated and an order was passed. And it is recorded that since it's a vested land, you are not entitled to any compensation. But it is also recorded that we have been given patta by the government. That is with your lordship's record, possibly 15th December order. To the contrary, the highway authority says that we have deposited the compensation, which is also recorded in your lordship's order of 23rd of December. So there is a triangle basically. One says it is a vested land. Again, it is said that there is patta. Highway says we have deposited the compensation. So we are in some sort of enigma. We do not know what is our stand today.
The stand taken by the authority is not recorded in the orders.
It's state authorities.
It's
Highway is
only
correct.
that, Notices have been issued to the petitioner. That's all.
Yes.
Nothing further has been recorded in
No.
the orders.
Yes. Then the hearing, there is a supplementary affidavit, my lord, which during pendency of the writ petition, they called us for hearing.
Mr. Dotto is appearing for the state. He wanted to come back with an affidavit.
Yes, my lord. I have
Possibly
the
both
side
the
of-
sides should come with affidavit because the stand of the highway authority is very important. They said we have deposited the compensation. So my lord, both should come with an affidavit. Subject to your lordship.
File by your, yes, I'll file.
Or report in that case.
Maybe Lordship, the report will be the.
Report would be convenient. Yes, I understand that. Then affidavit.
I'll file
My
it
lord,
out.
only one humble prayer before your lordship. Let it be preemptory in nature. Because my lord, this is for long it is pending, my lord.
None appears for the state respondents. So no affidavit in opposition is filed. Paragraph. Let the matter appear under the same heading on 18th September. Paragraph. Affidavit in opposition be filed on the adjourned date by the state respondents positively. Paragraph. The NHAI is also at liberty to use an affidavit in opposition on the adjourned date.
I'm so grateful to your lordship. Extremely grateful.
Oblige, my lord.
Lordship, one indulgence, Lordship. Item number 203, Lordship. No one appeared for a petition. I'm for the petition.
First,
Lordship, any date may be fixed, Lordship, in this matter. On the next date only. It was, any date may be fixed on the petitioner, Lordship. I beg my apologies. I couldn't follow.
order has been passed. I can.
It was fixed on any monthly list of September.
I do not know who was there on the other side. So I
I am on behalf of
Nobody would-
petitioner, my lord. The learned counsel is on list, my lord. Kindly fix the time date on the
Under
same.
17.
Huh.
You're for the petition.
I'm for the petitioner and the learned seniors are on list. My lord, kindly fix the matter on the.
Receive the affidavits.
I have received the affidavit, my lord, and I have already filed the affidavit in opposition in respect of
Not
3 and
opposition,
4.
reply. You are
Reply,
petitioner.
sorry, I apologize. And
India's affidavit is there. What about the state? Learned counsel for the state respondents seeks extension of time to submit the affidavit in opposition as sought. Paragraph, let the matter appear under the same heading on 25th September.
obliged.
আপনি খারাপ আছেন?
Petitioner,
I am for the respondent number 14 my lord.
petitioner. No one. There's an application also, can?
Yeah, but this application because there is a very interim order. And they are enjoying interim order and government is facing a loss of revenue. This is for flying ferry service.
Have you filed your affidavit in opposition?
Yes, mother. Today I am filing mother, but they have not served till date any copy of the reply mother.
এই তো opposition তো একটু
Kindly see mother the
opposition তো হয়ে গেছে এখন নেই তো হয়ে গেছে
last order passed by your lordship mother. Order date 24th of December 2021.
But none appears for the petitioner, let it be dismissed for default.
Interim order be vacated mother. Is interim.
It will be automatically. Yes. Affidavit in opposition filed on behalf of the respondents in WPA 14335 of 2021. There's only one matter.
There are two matters, my lord, and another matter, my lord. Both the matters we had analogous, my lord. Yes.
Already.
From the order itself, it is appearing.
Yes. 14335 with.
2846 and another written.
2846. Duty dismissed. Petitioners are same in both the
Yes, same,
matters.
same petition.
In both the matters.
Both the matters.
219 we have for the statement.
It's taken up on record. Paragraph none appears for the petitioner. Petitioner in both the matters. No accommodation is sought. Order to appointment. Dismiss for default. Interim order if any stands vacated. Actually, interim order.
Yes,
The application being is accordingly disposed of. Can 1 of 2022.
yes.
my lord, I am paying for not today.
Petitioner.
Petitioner.
State. Affidavits are not exchanged. Let it go out of list for the time being.
Lordship senior
Yes.
instruction me not today.
None appears for the respondents. So affidavits are yet to be exchanged. Paragraph, let the matter appear under the same heading in the monthly list of September 2023.
And the state, my lord, please. কত monthly list?
Where is your affidavit in opposition?
Affidavit দেয় না?
Yes.
In the meantime, I will take care of.
None appears to get up. Learned counsel for the state respondents.
ওটা edited
Seeks
copy আছে?
extension of time to submit the affidavit in opposition as such.
On my job. Wait, next month.
I beg to appear on behalf of the private respondent of 5 in WPA, my lord, 8464 of 2022.
I am appealing for the petition.
Both the matters? Affidavits exchanged?
Yes, my lord.
State?
Shishwarna Bandyopadhyay is appearing, he is coming, my lord. I have informed.
Yes, Mr. Roy.
Stated full cost.
This is a matter relating to, my lord, the initial objection which was taken by the state regarding the mandatory of writ application on the ground that the settlement of ferry by the government comes within the purview of the specified act and is not maintainable. On basis of which, my lord, the argument was advanced by my learned friend, Mr. Bandyopadhyay. হ্যাঁ শোনা আছে
The state needs to be there.
My lord, before my lord, my learned friend starts, my lord, I would like to, my lord, indicate two things, my lord. First, my lord, as per the averments made in the writ petition, my lord, they admits, my lord, the petitioner society, my lord, registered in 2020. And my lord, the e-auction required, my lord, kindly have a look to page 22. Page 22. My lord, left hand side, my lord, in middle portion, Nilam Sankranto Nothi,
Page 22 of?
writ petition number 8464 of 2022. Nilam Sankranto Nothi, statutory documents related to. These are documents related, essential. First, my lord, আর্নেস্ট মানি জমা সংক্রান্ত নথিপত্র সংস্থার দাবির সপক্ষে উপযুক্ত কর্তৃপক্ষ দ্বারা প্রদত্ত রেজিস্ট্রেশন সার্টিফিকেট ইত্যাদি যাহা প্রযোজ্য আয়কর দাখিল গত 3 বছরের। My lord,
and turn to page 50.
And my lord,
on the made, my lord, allow me to submit.
Let me
Page 57, government record.
Petitioner has to make his submission first.
Yes, of course, my lord.
And not only that, the state needs to be.
Page 57, my lord, if you logical down to page 57. Here, my
State is not there.
My lord, difficulty is, my lord, since last September, I am facing, my lord, interim order. My lord, in spite of we have deposited the requisite earnest money of 20 poor society, my lord, 62 lakhs paid. And that money is kept with the state government and we are not given possession. The lease agreement is ready. They have signed due to the order passed, my lord. We have not been handed over the position, my lord. Although, my lord, I have filed and taken out an.
That's the issue in the writ petition.
Yes, of course, my lord. Of course, my lord. That is why, my lord, I have filed an application that is appearing also with the application.
And
My
it
lord,
was
my lord,
directed by your lordship that it will be heard along with the main
Yes.
application.
So, my lord, my application, what I have paid, initially vacating and or, my lord,
Variation. You have paid
variation. So, my lord, I would beseech, my lord, that money which has been paid by us on the basis of the communication made by the, it was just paid, my lord, before my lord passed the order. And my lord, after taking the money, they have taken time, the state authority has taken time to give us the possession. And so far my instruction, my lord will find the person who has evaded the government revenue, they are still continue the possession, they still continue the operation. and the government, in spite of taking our money, my lord, whereas my lord, division bench, my lord, when my lord, subject to my lord's correction, my lord, in my application, I have annexed the other matter which I have, my lord, refused the interim order. Against that, my lord, the writ petitioner went up to the honorable division bench. Honorable division bench, my lord, did not interfere my lord's order.
Same
Rather,
argument which was addressed by my learned friend on the
Lord,
earlier occasion.
let me
Same
conclude, my
argument.
lord. Let me conclude. My lord, same time, same thing is going on, my lord. We are suffering, my lord, for last 1 year. With, my lord, kindly appreciate, my lord. The honorable division bench said, my lord, kindly have a look to the.
Are you appearing for the state?
There is two matters. I am appearing one matter.
In the writ petition which I am responded. That is the state, my lord. I have annexed all orders, my lord, passed.
Fresh notice on the state and come back.
He is representing.
Led by Mr. Bandhavadhyay.
Led by Mr.
My lord, I am suffering. Kindly modify my interim order to any extent so that I can survive.
What extent can it be modified?
My lord, the money which I have deposited, my lord, the money which I have deposited, I want to take it back. Because my lord,
Then my lord, entire thing will be, I am not standing in the way of giving money, or because I am not.
my lord, because the poor corporate.
The state needs to be there.
Now, my lord, then the entire process will directly be re-auctioned of the, in terms of the statute. Because the first, if went away, then my lord, the entire thing, I am ready and accept.
If my lord, writ petition fails, my lord, may I indicate the division bench order once, my lord? For
What will be the use in absence of the state? I'm not taking up the matter on merits.
my lord, then my lord, tomorrow at any point of time, my lord, kindly.
Matter at best.
My lord, my application be heard, my lord. I have last week, my lord, I have also mentioned for listing of my application, my lord. That has.
Mr. Roy, let it appear as an application. Let the
As
application.
the worship pleases, my lord. So, but if my lord, he is interested to take up the money, my lord, then the first candidate goes. The entire things will come within one. That is a.
If
so
my lord, ultimately, my lord, writ petition fails, I will deposit again, my lord.
No,
There
my
is
lord,
no
that
difficulty.
cannot be.
There is
Once
no
you withdraw the
difficulty.
money, it cannot be.
The money, you are out of the tender process.
Yes.
My lord, let my application be heard. Thereafter, my lord, pass necessary order.
I will hear your application only if you are interested in withdrawing.
Yes. Yes.
Your application is connected with the merits of the writ petition.
Otherwise, my lord, which my lord, my senior friend has referred one judgment of honorable division bench in our court. My money should be deposited in a interest bearing account. That may be done so that we cannot suffer, my lord. For last 1 year, we are suffering, my lord. In two ways, it can be solved, my lord.
That can be done.
Yes, that
Can be done.
I have not.
Application be taken up.
Tomorrow, my lord.
Not
Tomorrow.
tomorrow.
Application, my lord.
Joshua application heading আছে।
Otherwise, my lord, they will come again, my lord, seek extension of interim order because it is expired. 30th. As your lordship, please.
The interim order is up to 30th. 31st. Up to 31st, my lord.
Come back on 30th.
And interim order will.
Let me take up the application. He's asking for a variation. If the amount can be secured.
Yes, my lord.
Yes. So that indicate that portion, my lord. Otherwise, my lord, again it will reopen on the by way of application. No, my lord.
My application will come.
Yes, my lord. Can you record that only for the purpose of that? Otherwise, my lord, so
Variation.
For the, you are the respondents in?
My lord, I am respondent number 5 in WPA 8464.
Learned counsel for the 5th respondent in WPA 8464, who is also the applicant in CAN 1 of 2023.
Yes, my lord.
Yes, my lord.
Seeks variation of the interim order granted by this court to the extent that the amount deposited kept
This is
in
not restricted. So,
for deposit account.
Or my lord, I can take back.
Carrying
Keep
interest,
both the sides open, my lord. I can.
or he may be allowed to withdraw the amount deposited by him. Paragraph. The application being CAN 1 of 2023. Let the application being CAN 2023 be appear 23 appear under the heading application on 30th August 2023.
Since my lord, this due to paucity of time, my lord, writ petition cannot be heard, my lord.
Yes.
So my lord, I am in difficulty. My lord, kindly appreciate.
Yes, I'm not standing in the way, so what the matter is.
Stand in the way. Petitioner has no.
Now the state will come forward and say.
His counterpart is running the ferrygat. That is why, my lord, they are enjoying without paying any government revenue. Grateful to one.
ওটা ডিটাচ হয়ে যাবে আগের অর্ডারটা ডিটাচ হয়ে যাবে শুধু অ্যাপ্লিকেশনটা
সিনকয় নারায়ণ বেটা একটা কাগজ দিন লিখে লিখে দেন একটা কাগজ দিন। পাবি না কেন জানেন নাকি
Yes, affidavits exchange. Who is appearing? Petitioner. 223 petitioner. None appears for the parties. Your petition is sought. This is for default.
Edit is a petition. In this matter, I beg to obey the petitioner. May I file the affidavit in reply? Opposition.
Today, my clerk has missed the brief. He has not brought.
Who is appearing for the state?
No, state কি আছে? I have received. The receipt shows.
সৌমিত্র আছে সৌমিত্র না চন্ডিদা ডেটও দিয়েছে
Mr. Chakraborty, please inform the state once.
State has.
From the state.
My lord.
Because no affidavit in opposition is on record.
My lord.
Only the reply has come.
So state has not yet filed the opposition.
Please inform the state.
My lord, my lord.
State's report or affidavit should come.
No affidavit in opposition has been submitted by the state respondents or the hearing. Paragraph reply submitted on behalf of the petitioners is taken on record. Paragraph. Monthly list of September. Affidavits are not exceeded.
Affidavit have been, it will take very short issue. Man, kindly appreciate because we are
Come before the court.
very short issue.
Unless the state comes.
Monthly list.
Please speak to the state respondents so that
My
the
lord.
affidavits are ready.
Let this order be communicated to the state respondent.
Let this order, my lord. The monthly list of October. September. My lord.
September is also. Oh. You thought October.
I thought October.
I thought you wanted October.
I'll get.
Yes, my lord, I am for the petitioner. My lord, I don't think, my lord, at the fact end of the day, it would be possible for us to, argue the matter.
However, I am ready to argue the
Yes,
matter.
we are all ready. My lord, may I just say one thing, my lord? This is the matter where, my lord, my client purchased a property from the bank and DSDA gave no objection. And in spite of that, in spite of, my lord, direction passed by the higher authority of the state of West Bengal, the DSDA has taken a complete U-turn and passed the order. Mr. Biani's client. My lord, what I am being submitting before your lordship, my lord, it won't take more than 30 minutes any day if lordship can fix the matter and matter can be wrapped up. Well,
I am for the bank, my lord. I have sold the property.
State is not a party.
State is the party, but state has nothing much.
We
to
have
say.
not.
Mr. Bihani is the only person.
Only na, Baba.
For the state.
I'm not the only person. The private respondents are fighting more than I'm doing.
Yes. So kindly, my lord,
Go for the private respondent.
my lord, fix.
My lord, the only issue is.
So only Mr. Day needs to be informed.
No,
Yes.
have to that. Yes, that's
Yes. Any day convenient to your lordship. My lord, time, my lord, 3:30.
It's convenient to me, so.
My lord takes it up tomorrow, my lord.
মঙ্গলবার নেয় না
Oh, the Wednesday.
Yes, that's the difficulty. None of case for the state response. Affidavits are complete.
My lord, as a matter of fact, I have completed my argument also. Lordship will find that from the note itself. Yes. So that's why I am saying, my lord. My lord, only difficulty is my client is out of 3.5 crore rupees. He is crying basically every day in front of my advocate records office. My lord, I am just conveying, my lord, what is the situation.
So they.
Yes, of course. Any day, Lordship kindly fix it, fix the matter.
Fix করিয়ে দিচ্ছি।
Date.
কোথা থেকে কি করবেন?
1.5 মিনিটের মধ্যে মামলা করবো এটা পর
On, my lord,
13th September.
13th September. My lord, may it be fairly a top, my lord, just one line, my lord.
At 3:30, my lord, will it be lordship's place here at 3:30?
It is being called.
My lord, fairly at top, my lord. At least one line, my lord, be added.
My lord,
Lordship.
before your lordship, either if your lordship allows
I'm
me to
not-
trouble your lordship. My lord, 210 and 215, not I am for the petition. I was in that building. My lordship was posted in on 27 September.
Here I cannot.
My lord, my junior, no, my junior was here. My junior was here. But if your lordship, otherwise, well, I won't trouble because I'll really suffer.
The other side was there, Mr. Bihani. I'm sorry, I cannot go back to this.
No, I'm not asking your lordship to call. Instead of 27 September, your lordship puts it on any day, I can inform them.
The other side was there.
Well, I'll inform both of them. There is not a difference. May I mention then again? Well, may I take the liberty of mentioning upon notice again?
Since an order has been.
Lordship.
Lordship, may I pray, Lordship? Lordship, in respect of the item number 212, Lordship, I could not appear because Lordship, I
I'm
engaged.
25 now, sir. Please do not mention earlier.
Your Lordship, only thing, my lord, the learned advocate on record was sick, my lord. He entrusted me. I was on my legs, my lord, with regard to item number 218, my lord.
Past orders, I cannot go back on. I'm sorry.